Dear colleagues, I think we should start also with parallel sessions. As these are working sessions, I think the discussion can be quite lively and relaxed. My name is Gregor Sterban. I'm professor at the University of Ljubljana, so one of the vice presidents of the International Society. And we promise to keep you alive after an extensive lunch with interesting presentations. And we have a topic of extending social protection to gig workers with reference to Belgium and South Africa. So a great topic presented by even greater colleagues. These are Professor Stefan van Eck from University of Pretoria. I think Stefan does not need a special introduction. He's former vice president of International Society, former president of ALLS, African Labor Law Society. I should do it like that. So if you're a former, you're more than a current, I guess. You've done it already. He's also accepted as an attorney at High Court. He's a highly recommended researcher, C1 note, and a great scholar. And with us also all the way from Belgium, Professor Yves Jorens, University of Ghent. Professor Jorens is one of the greatest scholars of social security law in Europe. He's the leading scholar also in criminal social security law. He just published a book on cross-border EU employment and enforcement. So you're welcome to read that. And he's the organizer of the next Congress, which will be the European Congress, organized in Ghent from 6 to 8 September this year. So you're also very much invited to visit that Congress. Without further ado, I give first the floor to Stefan, then to Yves, and then we will open up the floor for discussions. So thank you. Stefan, please.
Thank you. Thank you, Gregor. I just want to hear, is the sound good at the back or any echo? Is it fine? Sounds good. Thank you very much. And then over to the slides. Our AVT. Is that it? There we go. Just point it in the right direction. First of all, thank you very much for the kind words, Pami. It's been quite a journey to travel with the African Labor Law Society. I didn't ask for those kind words, but thank you very much for that. And then I also just want to say thank you to my colleagues in front here. Both colleagues not from Africa, but we've become such great friends over the journey, both Yves and Gregor. I think they must get honorary membership for being the most well-attended African Labor Law Society connected delegates in the group. So thank you very much for being here. We are going to talk on 5 parts. I'm not going to read those down. I will start off, and that will be followed then by Yves. And we're going to talk about the protection of gig workers. Now, I mentioned on this first slide that from the South African context, when we talk about the extension of protection to employees or workers, mostly it comes from a labor law or an employment law perspective. Social security law is treated as a sidecar. And that is what makes this joint research so interesting to me. In many countries of Europe and in Belgium particularly, they don't talk about labor law protection, they talk about social law protection, and that includes both labor and social security law aspects. There's a lot about terminology, and we don't have enough time to sort that out. Whether one talks about gig work, fourth industrial revolution work, new forms of work, but there's a big collective, and somewhere in there we've got the definitions of worker, employee, independent contractors, and then dependent independent contractors. There's a lot of uncertainty about that, conceptual uncertainty. But we do know under this broad category of gig work, there's tremendous growth. Under types of work, many people know about the instance of Uber, Sweep South. It's projected In South Africa, 30,000 gig workers, some form or another. In EU, have a look at that number. It's projected 43 million by 2025. Now, quite a while ago already, in the EU, there's been some regulation of teleworkers. We had a good discussion about home workers or teleworkers, situation where you've got somebody who works removed from the workplace. And many in EU countries have got refinements that we in Africa and in South Africa in particular know very little about. Gig work is having a tremendous disruptive influence on the traditional employer-employee relationship. It's an extreme form of flexibility. Workers only work for the time they are actually being paid for. Let us think of the traditional Uber driver or a sweep south worker. That's typically where there are three parties involved: the app developer, the person doing the work, and then the client. So employees are excluded from the unproductive moments. Their remuneration is extremely low, and some of their fundamental labor rights are being undermined. How is this going to be regulated, especially in this tripartite relationship of where you've got the app developer, the worker, and the client? There's so many uncertainties. Who is the employer? Who is the employee? Are we actually dealing with employment? The big question. If we are dealing with employment, well, yes, then labor, or rather, let's call it social law protection, would become relevant. The ILO is acutely aware of this phenomenon. And the global report on the future of work was issued not too long ago. And in this, three main strategies were suggested. First of all, there should be a universal entitlement to continued training. So whatever type of a work a person does, investment must be done in upskilling and training for all people engaged in work. The ILO further said that there must be a strengthening of institutional arrangements, collective agreements, contracts, and there should be a basic guarantee that includes a living wage. The third leg or strategy is based on transformative investments in the green energy and also in the transformative economy. These are all very vague strategies. It doesn't tell us how do we protect vulnerable groups in the gig economy in particular. Bit more detail can be found in the Employment Relations Recommendation of 2006. And here the ILO in its recommendation said that member countries should define employment. They should adopt indicators and also probably include a presumption, rebuttable presumption as to who is an employee. South Africa adopted that approach. We've got a rebuttable presumption for lower earning employees. If any one out of 7 factors are present, then it's presumed until the contrary is proven that a person is in fact an employee. And the question now is, to what extent did this help Uber drivers in South Africa? We had our most significant challenge where Uber drivers who were removed from the platform approached our CCMA, the unfair dismissal law case, and the CCMA initially said, yes, they are employees. This then developed, and it went to our labor court, and in a quite, I would think, transgressive, backward type of a development, one of our esteemed judges, Andre van Niekerk, said Uber drivers are not employees due to a number of reasons. One being the contractual complexity. We've got Uber situated in the Netherlands, but we've got a Uber South Africa as well. So ultimately, these Uber drivers brought the incorrect, cited the incorrect employer. That's just the nature of the complexity of the whole matter, but our statutory presumption did not assist these gig workers in obtaining protection. I would think this is transgressive in as far as we've had very progressive decisions in extending the definition of employee. We've had people doing unauthorized work like prostitutes. They're not permitted in South African law, but if there's an employment relationship, the court said they're still entitled to the fundamental right to fair labor practices. Discovery Health, there we had undocumented migrants not being paid the minimum wage, and in that instance also the court said there's an employment relationship, they're entitled to protection. The CETA case also, it did not rely on the existence of a contract of employment or even a formal agreement. There's an employment relationship, yes, then there's employment. All of this did not help our gig workers at all. And then let us have a look what occurred in the European Union and interesting developments in Belgium. Friend and colleague, Yves, the floor is yours.
Thank you very much. It is really a pleasure, of course, to join you again at this African conference. My task is a little bit to shed some light about the issue of these gig workers, a topic that has a lot of interest in Europe. I think the fact that Stefan also mentioned, it is expected that we will have around in a couple of years more than 40 million gig workers in Europe. So you may not be surprised about the interest for these workers. I pose already workers between brackets. The never-ending story is, of course, how can we protect these people? Are they protected? What is their role? Often they are forgotten. We all know that they have a quite weak position all over in that perspective. The interesting thing, of course, and I think this morning we already heard some of these issues, is that the question about the digital revolution, the crowd work, the gig work, what's in a name, of course, it touched upon what I call also the traditional elements of a labor relationship. The employee, is it an employee? Who is the employer? This morning I heard some discussions, yeah, but if you would have an Uber here, it would be a contractor or not an employer. That's a discussion we got in Europe, and I come back to that immediately as well. And elements also, and that's even a step further, we question is that because a lot of our systems are based on labor. Labor is the method, of course, to get to contributions to the financing of your social system. Is that also employment that we should take into account, and how are you going to do that? There are different issues. Now, that last one, I'm going to leave it out, except perhaps a little bit up to in my last slides in the conclusions. But the first hurdle that everybody had to take at a certain moment is who is the employer? Because basically you have a kind of three-party system. You have a platform, and then you have the crowd worker, the crowdsourcer company. Who is now really the employer? And at a certain moment, the highest court in Europe, the European Court of Justice, had to deal with, not surprisingly, Uber. They become very famous in Europe, I can say. Now, Uber, of course, had in a certain way had a discussion, and the discussion was, it was in a Spanish case, but that was not the main issue of Spain or not. The question was, who is now an employer? And it had to do with a special EU treaty element. Are they really, because they say, look, we are a transport company and transport has a special place in the European Union treaty where they have a very special element around liberalization, why they exactly wanted to fall also under the transport element. The interesting thing, however, is also that they said, look, we are not a transport company. Uber is an electronic platform. We are an app that just brings together demand and apply on that. And that's all what we do. It's a kind of tool we provide. The interesting thing, however, is that the Court of Justice said, no, this is not true. What we say on a certain moment is that Uber is definitely an employer for us. The platform, and it's interesting that the Attorney General in this case, he formulated very nice by saying, look, we agree it's a special kind of employer-employee relationship because there is a platform with an algorithm that takes over tasks, but Uber is a platform on that. The platform provides the underlying service and as such is the employer. If not, and that's what the court said, you cannot say if you would take the platform away from Uber or whatever other platforms in the world, then you would basically only have a booking application system. But that's not the case here. That's an interesting fact because it shows immediately the employer is Uber. Of course, that doesn't say anything about the most crucial question. Number two, are then the drivers, for example, employees? Because that's another issue. Now, then you come, of course, to the issue about what is the concept of worker and how do we look at it from a European perspective on that. Now, you may not forget that the concept of worker, as we know it in a national context, has a slightly different idea in a European context. The reason is that worker was created there as a concept central in what we call the free movement of workers, of people. We can freely move between European countries and work. So the concept of worker was always interpreted by the Court of Justice as we should interpret in the way that the free movement can be encouraged as much as possible. So it's with an other underlying idea. It's not immediately with a labor protection idea. It's only at a later moment when we had several European instruments dealing with the protection of in social rights of workers that the concept will change slightly. It's also interesting to note that we have the European Union is contrary, for example, to the SADC, which is an international organization. For us, it's a supranational organization, meaning that the EU takes over part of the sovereignty of the member states. Now, the fact is, of course, that the EU in a certain way says, look, the member states remain competent in social law. They can refer to what is a worker, that's their national competence. However, will the court, of course, point out in the EU, you may interpret it, but within certain limits. Why? Because what we do not want is a certain, what we call arbitrariness. The risk is, of course, if you want to promote the free movement of workers and state A would consider it as a worker and state B and C not, then you would empty the free movement of workers. So that's not the idea about it. In order to avoid it, the EU started to develop some indications. And interesting is that in the different instruments that the EU developed after the last decade, often you will have either an instrument that says we define our own concept of worker, but then it's limited to its domain of this instrument. Either they say for a worker, we refer to the national definition. We refer to national law. We're not going to interfere. Or what is the current trend? They will say we refer to the national definition, but with this one important emphasis, taking into account the case law of the Court of Justice, showing that the Court of Justice will, as a Supreme Court, will give some guidelines. And that's what we see. And interesting is, recently, might be surprising for you, that after even 50 years of the treaty, we have very limited try to define at the EU level what is a worker. They said a worker deals with elements as performance of work, subordination, and remuneration. Now, what is also important is that the Court of Justice said, look, what counts if you define a concept is the clear precedent to the facts. You know, in labor law, you can either say the will of the parties has priority or the facts has priority. And the Court of Justice said, whatever you make as an internal agreement between two parties, the facts will be relevant. If the facts contradict the agreement, the facts have a priority on that. And also, not unimportant, the Court of Justice said the formal classification of a self-employed person under national law does not exclude the possibility that such a person might be classified as a worker in case this classification is purely notional, disguising a subordinate employment relationship. Transfer it into the concept of what we call bogus self-employment or sham self-employment. And what the Court of Justice said, these are elements that you can deduct out of the case law, because this is basically the issue about, at a certain moment, all the gig workers. Because we are always confronted with this binary division. Are you an employee or are you a self-employed? It's basically that question that has to be answered. Whether you create a third category with independent workers, it's also nice, but it's all the question about bogus. If you're real self-employed, you're real self-employed. But the problem with gig workers is often that they are in this very gray zone. And the court refers to several issues that are very important elements as guidelines. The nature of the duties entrusted, how is it performed? The scope of the powers. Can you replace yourself? Yes or no, which is typical for a self-employed person. Do you participate in the commercial risk? And the possibility to accept the tasks. Now, interesting, however, in one of these cases, that was a UK case when they were still under or EU treaty, this was dealing with somebody working in a platform work, and there the Court of Justice said, well, on the basis of what I see, it rather refers to self-employed. Yeah? So it will all depend on the cases. Now, we may not forget these are guidelines. And that is what is ever pops up wherever we are in international conference, all will depend on national law, how we look at it. And this is still the case, of course, in the EU as well. The court gives us some guidelines where we have to look whether you are a disguised employment relationship, yes or no. And that's where we have to look at. And that's also the reason why, and you can find some international websites where you can refer to case law in all other countries all around the world. Sometimes they are employees, sometimes they're self-employed. It will depend on the national situation and the national way to look at your legislation on that. Interesting is, however, that in order to solve that issue, the European Commission, the European Union organization started with making out the idea of a European instrument. And suddenly, well, perhaps suddenly 2021, there was a proposal from the European Commission for platform work. And this has raised an enormous debate. If there's one topic that is crucial at the political agenda of today, it's exactly this platform work. And the problem is, you have to know, in Europe, every 6 months, another country takes over the council, which means then the head, will decide about it, and every presidency suffers with this proposal. And in this proposal of the European Commission, they had an idea of making a rebuttable legal presumption of being an employee. They basically said, look, there are 5 criteria of control. And if these 5 criteria are fulfilled, or better said, you have a number of these 5, then you're considered to be an employee. That was the kind of presumption that was then installed. The criteria setting the remuneration, it's the platform that decides. Are they binding rules of appearance? Do you want certain control element? Is there a supervising performance? Often they refer to the star rating you have to do with platforms. If it's good, well, it has an impact on your remuneration, or you still have a job. Is it the restricting the freedom to organize one working time and the possibility to work for another client? These are the 5 issues that the European Commission put forward on it. This would lead to an inclusion, an extension, they said, of 4 million platform workers in Europe. But the council got, the proposal in Europe has to go then from the commission to the council, and the council had a problem because in some member states are really against this idea. They said this is going much too far. Other member states says, oh no, you should go even much further. So none of the presidencies succeeded in getting there. At the meanwhile, however, the European Parliament, which is a co-legislator, reached an agreement. They discussed the Commission proposal, but they make their own agreement. And there's something very surprising in it, because they basically upside down the agreement or the proposal from the European Commission. What the European Parliament did were 5 criteria. They used the same, but now they say, no, in order not to prove what the Commission did, 5 criteria in an employee, the European Parliament said the agreement is platform workers are employees, but if you can demonstrate on these 5 criteria that they're self-employed, they will be self-employed. But this is upside down what the European Commission did. And this now leads, of course, to huge discussion. Some member states are upset by that, others welcome. Now we have to get to an agreement because, the council has not yet an agreement. The parliament has. Both have now to sit down together in the commission in very difficult trilogue procedures. And we never know what the outcome will be. It might effectively be that we never have an instrument because both have to agree it's a co-legislation element of that. Interesting is also that they inserted 2 other conditions. One, our algorithm is many used in this world, and it's not only for in the gig workers, but every employer, if you use an algorithm and doesn't what in what, then you have to give adequate information to the employees. And secondly, algorithms have an impact on privacy rules, and there you have the possibility these should be respected fully on that. Now, very quickly going, because then we have Belgium. Of course, the element, Belgium, we had the same issue. Are we employee or self-employed? Well, some people say it's some of the courts said self-employed and others said employee. We have a labor relations commission. They couldn't get the same result on that. On a certain moment, we did something very special. Often we are self-employed gig workers. Why? Because we have in our legislation a presumption that if you declare income as in fiscal law as a self-employed, that you are, it's rebuttable, that you're presumed to be a self-employed under social legislation. Now, our government wanted to promote gig working. So what they did on a certain moment is we're going to encourage that. And they had one problem. They say this, electronic platforms, we don't know who they are. So what we're going to do is we're going to help you. If you register your platform, then everybody who works for them will have a tax-free up to 6,000 euro a year, where they don't have to pay any taxes on it, neither social security contributions, because that would be the way to get work out of the undocumented labor, the black labor, as we call it in our terms. And the objective was legal certainty. Don't worry, 6,000, you're free of everything on that. The problem was, of course, that a lot of organizations said, yeah, but that is unfair discrimination because you can do this work as an employee or a self-employed, and now you have a third group that is doing it for nothing. That is not the way for that. And our Constitutional Court indeed agreed on that and say, this is the world turns head up. You want to counter undeclared work by giving people a non-status, because you can work for a certain amount of money without any protection. And that's the way you're going to solve the issue of people who don't have protection because they're undeclared. So that is not possible. So there is no justification, and that points up to the interest. So we had to forget it. And then the Belgians, who are normally a little bit slower in adapting EU legislation, found the best that they could do is we're going to be a very good pupil, they said, student from Europe. We're going to take over the commission proposal into our legislation when gig workers are employees. So the same they did, more or less the same on that. The interesting thing is now that Belgium says we will then already have implemented immediately this proposal. The only thing is that the proposal is now completely different. So we might have been in a situation where Belgium adopted a proposal that will never be adopted. That is sometimes interesting on that. Now, I just want to stop with one issue about that is, of course, we call it Quo Vadis. What are we going to? I think we all agree that gig work is there and it is growing, and we have to, we have to embrace it one way or another. And it's an extreme example of the flexibility of the labor market. I think once there was a quote of a CEO of an American multinational who said the advantage of gig working is I just have to click on an app and the employee is fired with all this administrative hustle I should otherwise do. He said, it's perfect. I love it. That is the way that some people look at it, of course. The problem is, of course, that these gig workers are often to be set in a very poor situation, are not protected, have the risk to be a second-class person in all these elements. Now, that is something I think we have to embrace. We have to give them protection. What is also important on that is, of course, how do you give protection? Well, for me, it always turns up to this binary division, which is so global in the world, between an employee and a self-employed. But it remains a conundrum for every state. Every state has its own role, and almost every state is not in a position to solve that issue. With even a legal presumption or case law, we always suffer on that issues. And we have to see, can we solve that? And let's not forget that this is one of the issues we have to do. Can we arrange it on a global level? If you look to the EU, we use 5 criteria, and we immediately know that before national law, it will be discussions about these criteria. Combating bogus self-employment is also a communicating vessel, meaning like that you think you close the door on one and immediately another one opens because people try to escape. If you see in our countries, a lot of people start to set up constructions to companies to explain that they are self-employed. And this is my last one. I think we have to take care of that. As I said, they may not be seen as a second-class marginal labor. We have to include this. A lot of gig workers do it either because it's necessary for them. It brings a lot of money, at least. They need it definitely on that. I think there's a need to include everybody who performs useful work in our social security and our completely protection system. That's why in a certain way I plead a little bit also for a new concept of labor, being not the labor as the traditional way we look at it, like the employment-employee relationship, but really consider that labor is also the entrance ticket to the right to usefulness, even for that activities that are not normal, between brackets. We should protect these people. A lot of people do as small things of jobs for everybody, and we do not consider it as labor, and that's the risk for that. And that would imply that labor is not the basis then of our protection system, but perhaps the purpose of it. And I sincerely hope that gig workers would be as such an example to trigger this debate we might have not only in Belgium and in Europe, in South Africa, but all over. How can we protect people who are otherwise in a certain way considered as a second-class marginal labor force? I thank you.
Thank you again, Stefan and Yves. The presentations were, I think, challenging. We are a bit behind schedule, but still, I think, open a discussion for another 5 to 10 minutes. It's always the question of work and workers. I think we more or less all have to work to survive. It's just a matter of how the work is organized and how it is dealt with in labor law and social security law. But we'd be happy to listen to your thoughts as well. So any questions, reactions? Yep. Maybe 1, 2, 3, 4, 5. That's all. Okay. Yep. Start at the back. Okay. Do we have any mics? Yeah.
Okay, yes. Hello, thank you. First of all, I'm Benoît Lopez from University of Paris Saclay, France. And first of all, thank you for the presentation. That was really amazing and interesting to listen. So my question is about the two panelists. You can choose who respond or both responds. In France, we choose to have, you talk about second-class worker. We have a second-class representation because we start law for not unionize the gig economy, but you propose a representation, but they are non-union, they are just like a normal association. So do you think it's a good idea to have both union and NGO or association for the platformers worker or the gig economy? Or do you think we have to enforce union and union freedom for the gig economy? Thank you.
Thank you for your question. We will collect all the questions first in the interest of time and then answer them in one go. Please, the floor is yours.
Thank you, colleagues, for the presentation. Something that I thought of actually while you were speaking is, in South Africa, one of the ways in which the dispute as to whether someone is an employee or an independent contractor comes to the fore is maybe through a dismissal dispute. And then at the point of the dismissal dispute, the employer raises the point to say, this is not my employee. This person is a contractor. The CCMA doesn't have jurisdiction, for example. And I wondered if there's any value in considering, I suppose maybe it's a positive presumption, but I wonder about a system where it is presumed that everyone is an employee and it is the employer who must apply to be exempted or to have certain categories of employers exempted within their workplace. And I think I've got a number of reasons why I think that would probably be more fair to employees. But in this context, for example, if you're talking about Uber, it would be Uber as a company saying, we want to exempt this category of workers from employment regulation in relation specifically to the LRA, the BCA, or whatever the case may be. They must apply, not employees having to litigate to enforce their rights.
Yeah, for a question, we have 3 more.
Okay, thank you very much, and thank you for the presentations. I know that the subject is very, very complex, and what is applying to the Uber drivers is also applying to the Airbnb holders. And I don't have a question, but I have just information to provide you as ILO. Since 2013, ILO was working on this concept. And during the 19th International Conference of Labor Statisticians, ILO statisticians, they reviewed the concept of work, concept of employment, employers, and so on. And then in 2019, during the 20th International Conference of Labor Statisticians, they review the concepts of employers in the and also take into account the definition of the kind of workers, the people who are working as Uber, as Airbnb. So I have the document with me. I will share with you so that we can it can provide you more detail on what you are saying, because the situation is very, very complex. What does it mean, work relationship? All this one are defined in the document. So I can share it. It is called, sorry. Yeah, it is called, the document is called, it's called 20th International Conference of Labor Statisticians on relation.
Thank you very much.
I will share with you.
Yeah, I think we can also labor-intensive platforms and capital-intensive platforms, which are 2 different kinds of platforms. We have 1 more question, I think. Yeah, we promised 5 questions, and then the reply will be in one go.
Thank you very much. I'm Rashid Olsen, Redundancy Board, Mauritius. I would just like some further clarification on the those who are engaged in the gig economy, and to get them to register and be recognized for the purpose of obtaining protection. Do they then remain in the black economy? Is it not the purpose of going for these people also for tax purposes, so that they contribute for tax purposes to the economy? Thank you very much.
Thank you. I think we have accepted all the questions that we have time for. And I will just briefly ask, and I think it was 5. Yeah, Georgina, sorry. Should not miss Georgina. Yeah, I'm sorry. You said 5, you only took 4. Sorry, Georgina.
Thank you very much. For me, working in a tech company, we have a lot of young, and I would say millennials who we work with, who right now, even just getting them to come to the office is a tough call. They just want to be given projects that they work on and they be paid on it. They don't want to be confined in many policies. They don't want to be confined in a lot of contracts and documentation. And this flexibility works from them. As the world is advancing and technology is also advancing, we're getting to the point where we're becoming even obsolete. We can go on to applications that give us answers. If right now we didn't have to attend this conference, we could have even created one on ChatGPT. Now, where do we fall when we're trying to box in these into individuals into employment and social protection, which ideally is the right thing to do, and we should already be doing it without it being over legislated. But how do we get that balance also, keeping in mind on where we're going globally?
Questions. I think it remains to be seen how the conferences will be organized in 10 or 20 years, but if the venue is nice, I think we'll still be coming. So please, brief answers.
Thank you. Let me see from the top and just make 1 or 2 comments. Is it better to have NGO type or rather unions? I would support both. Sometimes the NGO type of organization could develop over time into unions. That would be my first take on that. Then some of the other questions about the new millennials who really don't want to be caught up actually in formal type of jobs as we know that. Well, some of those forces are stronger than what social law could dictate. It's an evolutionary process, and yes, it may be so in respect to certain parts of people being useful or rendering service, but no doubt there will definitely be in these categories people who are vulnerable and who will always remain in need of some social protection. I would be very interested in that ILO policy document, if that could please be emailed to Claire and to Connor. We'd like to distribute that also to all society members, if that could be possible. And then I think the last one that I will touch on, and then maybe Yves can touch on some of the rest, is the issue of should all platforms not be be deemed to be employers, and then they've got to disprove that they're not employees. It's quite a novel idea. I just think within that, there may be some categorization problems. Is that every tech company, will all of them then be anybody rendering service? Just that starting point. Who would be those big entities that would be presumed, if you want to go that way around, to be employers? Who do you put within that pool? Or is it anybody who is making money in some form, whether you've got an algorithm or not? If you can solve that, then that is definitely a viable suggestion. Something new, novel. I haven't heard about that suggestion before.
Thank you very much. Trying to get quickly over all these questions. Collective rights. Yeah, I mean, presumably, of course, we all understand that for the moment, these workers have not really any collective rights or are not represented. This is also the reason why the EU, of course, is currently developing an instrument or working on an instrument, of course, on collective rights for self-employed people, because they are often forgotten. They don't have these elements. And this is, of course, also now linked with what is happening in the platform work and all that. So that's one element. I think in the first place, unions can play a role there. The positive presumption of everybody being an employee and then rebuttal. I think there might be some temptation to get in that. The other element is that you always hear that is whenever we cannot protect somebody, we make them employee. And that is some things I found we should take care that we don't throw the baby away with the bathwater. I mean, basically say, why should we basically exclude self-employment? Self-employment is existing all over and there's nothing against it, of course. So we should take this on board as well. There's a fear, of course. I mean, is anybody going, are employers or employee or self-employed people, are they then going to the court that costs money to say, no, I'm self-employed and that perhaps the step is going too far on that? Then I had something I see here. Yeah, the financing also element clear. I mean, everybody who will then be protected will be part somewhere of paying contributions or financing or taxes, of course, in the whole system. And that will be necessary on that. But I see everybody is approaching me from left and right that I should shut my mouth. So, I mean, I don't know, we can discuss further on it then during the break on that. The last element, of course, let's be clear. Platform work, as it is here considered, is the situation where we're dealing with an app that brings basically two parties together. We're not speaking here about the big tech companies with the flexible work and homework, because that's a two-party agreement. So this is definitely dealing with a separate category of persons. I have to stop, I think.
Thank you, Stefan. Thank you, Yves. I think labor law and social security law have to always adapt to new developments in the labor market. So thank you all. We make a very brief pause, so don't go anywhere. We just exchange the speakers and the moderator will stay the same. I would like to thank Stefan. We made a wager at the beginning. If they get an applause, they get a gift. So they did get an applause. Okay, so without further ado, we continue with the schedule. I think the topic has remained the same. Okay, so the topic is, I'll be watching you. Workplace monitoring and data privacy. It should be the speaker of Priscilla Balgobin-Boyeroul. Okay, and now we have a speaker of Juhi Densai. Sorry for my pronunciation. Juhi Densai. She's a barrister at the Dentons, so the same company. She has a long experience. She's one of the best advocates and lawyers, and you can read more in the bio, so I will not repeat whatever is written there. Juhi, please, the floor is yours. You have 20 minutes.
Thank you so much. Good afternoon, everyone. I know you've been processing a lot of information since the morning, but we are now going to talk about employers processing data during workplace monitoring. So just for the prevailing laws in Mauritius specifically, obviously the governing law is Data Protection Act. It is aligned with the GDPR. We also have the Constitution, which then brings you to privacy of home, right for the freedom of expression. And there is also the freedom from interference with an individual's correspondence, which is not expressly stated in the Constitution, but obviously is interpreted by case laws. We also have Mauritian Civil Code, which is derived from the French Code of Napoleon. We've got Article 22, which provides that an individual has a right of respect to his private life. Obviously, no specific guidelines or directives when it comes to workplace monitoring. We're lagging behind when it comes to that specifically. But without going into the legal basis, let's see what are the different types of monitoring. Obviously, you have monitoring of email content and traffic. This is usually done by keywords, by checking destination addresses. You have the monitoring of internet use. This is usually carried out by looking at the different websites that employees access and cookies. You have the monitoring of calls, we all know, recording conversations, whether it's Zoom calls, whether it's called telephone calls, biometric attendance. It has been here for ages now, facial coordinates, fingerprints. There's obviously the monitoring of conduct. We've talked a lot about CCTV footage, and CCTV is being installed since the morning, so that's a bit about this. Obviously, monitoring can be conducted by specific checks or on a random basis. So before choosing the legal basis for processing such data, we need to ascertain what is the purpose. Why should employees be monitored? So there are a lot of different rationales and bases that employers tend to rely upon, which ranges from detecting cases of harassment, detecting if there has been any sort of defamation, detecting if there's any sort of contract that has been concluded through emails unwantedly or unknowingly, obviously hacking, all sorts of technological hacks, poor performance, any sorts of physical violence or conduct that's happening. So these are a lot of different purposes that an employer can come up with. Going to the legal basis, obviously the law provides for 10 different legal bases, which I'm not going to go through today, but we've been talking a lot about consent since this morning. Employers tend to take consent as a blanket approval for processing data, but let's not forget, consent needs to be freely given, specific, informed, and unambiguous indication of the agreement of an employee. Is that always the case? I'm not too sure, because employers and employee do not negotiate on equal conditions. And it has been reported globally, even by the ICO, Information Commissioner's Office, that the use and reliance on consent in employment contexts must be exercised cautiously, because there is a clear-cut imbalance of power in the employment relationship. Therefore, employees should be given a genuine choice. You can't just put a consent clause in their contractual employment, which they will have to sign anyway to get the job and get paid as part of their acceptance for data collection and processing. So there are other bases which obviously where consent is not needed and where employees can rely upon, which is the performance of the contract in itself and the execution of the employment relationship for compliance with any legal obligation, and obviously legitimate interest that we've been talking since the morning again. I'm going to touch on a few decisions of the Mauritian Data Protection Office and a few of the legal bases that have been identified and upheld through those decisions. So for example, for biometric attendance, there are decisions that tells you, look, consent is required because there are always alternative means through which attendance can be recorded. For example, if it can be secure without fingerprints and facial coordinates, but by signing an entry book or by tapping a card, why should data, sensitive data, such as fingerprints and facial coordinates be processed? CCTV recording, the stand of the Data Protection Commission in some cases has been that employers can rely on their obligation, on the compliance of their legal obligation to provide for the health and safety of employees, to justify the need to put CCTV cameras, for example. Call and email monitoring, that's not too clear-cut yet, because obviously it can be argued that if the equipments that are being used for those calls have been provided by the employer, then the employer must have a right of access, because anything that you're supposed to do is obviously by virtue of your employment relationship and for the business of the company. So then employers tend to rely on legitimate interests that should be pursued. So it should be noted that when we talk about legitimate interest, it's a big word, but that interest cannot be overridden by the interests or the fundamental rights of the employee. That means any processing of data during workplace monitoring has to be done proportionately and in the less intrusive manner possible. Now, easy said than done, for sure, but that's the entire balancing exercise that employees have to keep in mind, especially with the evolving technology. I'll make a reference to a Mauritian case, which dates back, the judgment dates back to 1993. So that's even before the GDPR and any data protection laws in Mauritius. But in that case, it was held clearly that the employer does not have the right to open a letter which has been addressed to one of his employees. So that brings you back to the constitutional rights that any person has, irrespective of whether it's an employee or anyone else. So what this is more for the employers, if any in this room, is you will have to make sure, and every employer has to bear in mind, that there should be some form of structure. It can't be just across a board decision that you decide, okay, as from tomorrow, we're going to start monitoring, we're going to install CCTV. There needs to be a whole program and a work that goes behind it, because there are different data protection principles that, first of all, have to be abided by. The first principle, obviously, is lawfulness, fairness, and transparency. So what does that mean? This effectively provides that there needs to be detailed information to employees about the monitoring activities in the first place. You can't just decide, oh, I'll pay someone, get the CCTV camera installed tomorrow. There needs to be communication prior to such installment, even if that's, for example, due to your legal obligation or whatever. As was said earlier, there needs to be transparency. There needs to be some sort of notice. And then the second principle, of course, is that you can't just collect for any purpose or randomly. There needs to be a specific, explicit, and legitimate purpose why you're collecting that data. And when that is specified, there needs to be gatekeepers who ensure that the data that has been collected through those monitoring activities is not processed otherwise, because then it completely changes the legal basis. So the principle, again, of proportionality is very important, is very relevant for concepts of workplace monitoring. And it will not simply be enough for employers to say, hey, look, your email is being monitored as from tomorrow. The employees need to have a clear understanding of the method which is being used, first of all, to monitor those emails, the information that will be collected during that monitoring, why is it being collected, for what reason, what does the employer want to know or pursue, how will this information be used or stored, and who will it be disclosed to? Will my colleague who's sitting right next to me get to know everything that's happening, or is there some sort of means? Who is going to get those information? So in addition to all that I've said, there are obviously Section 23 of our Data Protection Act provides for some sort of notice to be given, which includes several other information, such as the data subject's right to complain to the Data Protection Commissioner, their notification if there's going to be any sort of transfer abroad, and amongst other things. Purpose limitation, I'll just go briefly on that. As I said, if, for example, you're using CCTV for security reasons, it cannot be used to establish the poor performance or any other things, because that's not the intended use, and that was not informed to the employee. So it is also very insufficient, which I've seen very commonly happen, for employers to just put on a privacy policy on the website and be, hey, I've got a privacy policy, I've satisfied my obligation of notification. No, employers needs to start realizing data protection requires an additional step, requires additional resources to be allocated. You have to ensure that the contents of the policy are properly understood. People have taken note. And now, how can you do that? I'm not an IT expert, but this can be maybe setting up some systems where the employer can ensure the workers have read the policy, have not just opened it, closed it, I approve, read, No, there needs to be some sort of prompt, which maybe shows that they have to compulsorily go through for a certain period of time. I mean, I leave that to IT experts, but the entire essence is that no, employees need to be trained, need to be informed, not just given a policy, I consent, and I've read it, and that's about it. Data protection impact assessment, employment monitoring, workplace monitoring definitely would involve a high risk because of the entire balancing exercise that have to be carried out. So it will be an express requirement, actually it is in Mauritius, in case of high risk, to have a data protection impact assessment first. And again, everything needs to be recorded, the form of monitoring, how is it proportionate to meet the needs of the employer, and what are the risks to the rights and freedoms of the employees? So the right balance needs to be struck. For example, let's say for an harassment policy at the workplace, an employer may decide, okay, I'll have to monitor internet use to prevent employees from accessing or displaying inappropriate materials within the workplace or in an open plan office. But for the employer to show that the monitoring is indeed proportionate, it would have to also assess whether there are less intrusive ways to do that. Can't it just be done by a combination of, let's say, harassment training, or, for example, proactive management, or dealing with problems when it arises? Wouldn't that be sufficient, for example? So obviously there needs to be some sort, when we're thinking of a method of monitoring, the first question we need to ask ourselves is there a less intrusive manner? Is there, instead of monitoring emails, instead of monitoring the contents, can I monitor email traffic, for example, or should I monitor the content? So there's always a lot of series of questions that needs to be asked, which needs to also go in the impact assessment report to show what are the considerations that has been taken. So I know I'm really short on time, so I'll not dwell too much into a lot of things, but data subject rights, we've talked extensively. Obviously, the right to request access, they have complete right to request access of the records, even to have access to, let's say, okay, there's CCTV, I want to know what is the recording for yesterday, can you please show me? Now, what employers need to also be cautious about is it must not adversely affect other people. CCTV right now may be covering all these people, not just because Shrivan has requested, for example, right of access, that I have to compromise with everyone else's data. So there is a line of caution that needs to be drawn on that basis as well. So obviously, retention period, we've talked about this. I won't dwell into it. Employers just can't keep data to say, hey, it might come handy one day. It needs to be reasonable at some point. Short word of caution with the risk of monitoring. I know we've talked about this earlier as well, is that there may be risk with monitoring at the workplace because there is an implied, if not expressed, duty of confidence and trust which goes into an employment relationship. And such sort of monitoring activities can be on the fence, and the employee can sometimes claim constructive dismissal if that line is crossed. There can also be employees who believe they're unfairly targeted from some sort of monitoring, and they can also have claims of discrimination if not constructive dismissal. So going on the global provisions, I'm not going to go through all of these. You can already see it on the slides, but these are very interesting to know what countries around the world have and how certain principles and provisions have been ruled and judged so that we can draw some inspiration. So for example, in Italy, the entire law behind email privacy is that for non-personal emails that not only relate to job, there must be an internal policy on how these emails will be handled, with an explanation of how the employer controls the laptop. Okay, I've got internet outlook for my work emails. Can I go on my personal Yahoo or Gmail, for example? So all this needs to be informed, and the Italian Data Protection Authority did conclude in one of its decisions that maybe an automatic disclaimer in the email body clearly stating that the communication is not personal and can be monitored can be useful and is recommended. The same thing happens to accessing email accounts of employees who've left. The Italian Data Protection Authority did state that you can't just keep it indefinitely. Oh, there's not been a handing over. Let me just keep everything that the employee has on his laptop. It does not work this way. There is some sort of steps that needs to be taken with deactivation and deletion of the email accounts, and maybe implementing an automatic alert, rerouting those communications. In the US, obviously location monitoring, I'm not going to go on that. Let's go on artificial intelligence. So New York has become the first US jurisdiction to adopt a law that governs the use of artificial intelligence and automated decision-making tools when it comes in making employment decisions. So when it comes to recruitment, when it comes to carrying out employment functions, and this new law will only be enforced next month in April 2023. And what it actually states is that obviously it requires notice, it requires audits, such as the data protection impact assessment, to be able to implement such tools. Brazil, on the other hand, it was stated in, it's the law over there that employees are not allowed to access the personal accounts of employees, such as email or messaging applications, even if those tools are on the employee's equipment. So coming back on the WhatsApp query we had earlier, even if you've got your personal WhatsApp on your work phone, for example, if you're based in Brazil, the employer would not be allowed to go into that. I'm sorry, is the clicker still working? No. Can we go on the next slide, please? Yeah, here we go. So I've listed a few of international cases, just to draw some interpretation of how it has been evolving. So obviously there is Kaplan in UK, which is a judgment which dates back to 2007, where the European Court of Human Rights considered the monitoring of employees' telephone, email, and internet usage. And it was concluded that Article 8 of the European Convention, which is the right to respect for private life, family life, home, and correspondence, was actually infringed, where there was no information or privacy policy in the workplace, and where the employee was not specifically informed that obviously there is some monitoring that's going to happen for your emails, or for example, from the Outlook that you're using on your laptop. Going to Barbulescu in Romania, that's a pretty long and very interesting battle that happened in 2017, and which considered private sector's employers' monitoring of an employee's Yahoo Messenger account on, obviously, at work, basically. And Mr. Barbulescu was dismissed for personal internet use at work, contrary to obviously a policy, which in that case, there was a policy. It was strictly prohibited to use Yahoo for personal use. Now, what happened is that as part of an investigation, obviously the employer accessed some intimate messages that was sent to family and fiancés to the family of Mr. Barbulescu, and the account was actually set up for work purposes. But Mr. Barbulescu sent an email to his own personal Yahoo Messenger through his work email. What happened, the messages was printed by the employer and was used in disciplinary proceedings and in subsequent court proceedings. And the Romanian court initially upheld the dismissal, saying there's absolutely nothing wrong, you can carry forward. Even the European Court of Human Rights initially held that it was a very controversial decision, but initially held that it was proportionate with Article 8, which I've just stated earlier. And part of its rationale was that, look, it was not the content of the messages that were important before the domestic cause, but it was the actual existence of having used the work account for some personal reasons. However, this has been overturned by the Grand Chamber in 2017, when they actually held that Article 8 had been infringed. So the employer's restrictive internet policy meant that it was open to question whether there was actually a reasonable expectation from the employee of his privacy in this situation. And the court noted, which, let me quote, that an employer's instructions cannot reduce private social life in the workplace to zero, I unquote. So basically, that's a very fundamental decision that came through, which again shows there's an absolute need for a balancing exercise. You can't just have a draconian policy and think it's all ruled, governed, yeah. So in that case, the employee had not been informed that the nature and extent of monitoring, the nature and extent of the monitoring, and that the employer can actually access the messages. All this was not written in the policy, and even if that was written, the Grand Chamber did state that you can't completely reduce an employee's social life to zero. I mean, it's not two different peoples. Coming to Simkin and Berkeley Group Holdings, the High Court rejected the employee's, Mr. Simkin's, application to restrain his employer from relying on what he says, private documents in the contents of an employment dispute. So the documents were actually emails and attachments from his work computer, which was sent obviously to his personal email for the purposes of, I mean, he wanted to just forward them. And the court held that the email actually was not confidential. Mr. Simkin had signed an IT policy, that he understood that policy, which clearly provided that emails sent and received from the IT system of the company or the employer's property, and did not find any issues with that, and said that the attachment, since it had been created during the course of employment, did not breach any laws, and it was completely all right to do it. So I'm still good with time. Okay. So okay, conclusions. So, okay, so I'm managing time well. We'll reach to the conclusion part. So again, just drawing the line and summarize everything that I have been saying. The worker's private life extends to a workplace. In the end, they're still human beings. Anything extends to the workplace, and they do have an expectation of privacy even when they are at the workplace. So, and even where they are informed of monitoring. So if a monitoring has to be carried out, please ensure there is a rigid data protection impact assessment that's done, recorded, ensure you've got it within your files. And again, the entire rationale behind workplace monitoring: proportionality, balancing of exercise, transparency. These are the key words that all employers have to bear in mind. And yeah, who gets the data? A limited number of people should be able to access the data. It can't be, oh, I'm monitoring you. Everyone knows everything about everyone. I mean, yeah, we need to be really sure on who is getting that data and who is involved. So like I said, going back, resources have to be allocated to privacy and data protection in any company. So thank you so much. I hope you process all my data regarding data processing. We may take a few questions. Yeah, thank you.
Thank you, Juhi. We've been watching you, yeah, quite closely. So we still have time for some questions. We collect all the questions at once. Any questions? One, two? Okay, two questions.
Hello, I'm Bertie Francois from Juris Consulting Mauritius. Thank you, Juhi. It was a brilliant expose. Allow me to seek some free legal advice from you. We were speaking about work from home this morning, and when we're talking about workplace monitoring, now it has another dimension. The exact question I want to ask you is, how far can an employer go if you want to add a software to your computer, for example, to monitor, to capture your screen every 5-10 minutes, to monitor whether when you are at home, you are actually using the computer, you are actually working. Bearing in mind, let's say, with respect with what you just said, that the employer notifies the employee, the employer also notifies the employee that the results of those captures will be taken into consideration whilst assessing poor performance or not. Yeah, that's the question. And the second thing being, if I am the employee in that situation, you mentioned constructive dismissal a bit earlier, and whilst you were talking, will I be able to claim constructive dismissal? Thank you, Juhi.
Thank you. Thank you very much for this very interesting presentation. My question or comment builds a little bit on what the gentleman just mentioned. I'm very concerned about the readiness of nations, many African nations, including Mauritius, in terms of implementing some of the facets of data protection, given that a lot of this is based on the GDPR, which comes from Europe, which comes from countries that had already established some level of data protection in their systems. Now we're trying to implement many facets of these in nations that have just started to understand what data is, and even employers understanding what is valuable data and what should be collected and how it should be used. So what are your views on, for example, making this more of a phased approach, where policymakers and employers get to understand it at a phased approach rather than just throwing everything on the system and expecting people to, and employers and employees to understand as well. The other thing I wanted to comment on is we've heard the word consent quite a lot since this morning. I know in the African community, people speak so many different languages. How do you get, even in the case of Mauritius, how do you get somebody who is not, literate enough in English or French to understand their data rights at work if that's printed in English and French in the workplace? Thank you.
Thank you for all the questions. Juhi, the floor is yours.
Oh, thank you so much for your question. Yeah, of course. So when we're talking about working from home, that's where it becomes very tricky, because the employer can say, look, I've got a legitimate interest. It forms part of the employment relationship. I've given you work. I need to see if you're working, for example, because you get paid for it. But having said that, I'm sure everyone has heard about Team Viewer. There was a whole debate around Team Viewer and how it can be accessed and whether a passcode needs to be given by the employee before whoever accesses it.
Also the exams.
Yeah. So basically, I would say, look, there are a lot of legal bases where the employer can rely upon to do this. Every 5 minutes, I don't think would be rational and would be highly intrusive in that case and won't need the proportionality test. Having said that, in a work from home situation, as far as let's say you're trying to access, you've informed that you're going to access the laptop not randomly. Obviously, there must be a means. If there is a system that's running ongoingly, that's the question. Will that be deemed to be highly intrusive? We know there's a lot of apps that continuously monitor your time spent on Outlook, time spent on Google Chrome. So I think it can be justified, but at the same time, notice what information is being collected. Why is it being collected? What is the reason? Is it just to know that you're in front of your laptop, or is it to know if you're working well and sending the right emails? So is it poor performance, or is it just work? So, I mean, there are lots of distinctions to be drawn. Constructive dismissal, not too sure that can be claimed. It will really depend on the type of monitoring in that case. And coming to your question for phased approach, I totally agree. So even in Europe, it's only I won't say the timeline because I'm not sure about them and the dates, but it's only fairly recently that they've come up with specific guidelines on workplace monitoring. So there was the GDPR, yes, but then they realized, okay, look, we're talking about data, but data, I mean, it's vast in every different concept. It can be interpreted very differently. And about workplace monitoring, what happened is that they removed a directive and a guideline. So I think, true, in all these African countries, we need to take it one step at a time. But unfortunately, since the law is already there and employees are becoming more and more aware, we've been getting a lot of data protection cases. We've been getting a lot of cases in our civil jurisdiction for damages concerning breach of data protection, etc. Because employees are aware now, for example, and they won't wait until there's some guideline or directive on workplace monitoring to enforce the laws. But I totally accept and agree for a phased approach, and I think that the relevant authorities need to work on it sooner than later. And concerning language, yes, that's what I meant. You can't just have a policy and say, okay, hey, sign this policy. You need to go one step further. If that person doesn't understand English, is not literate, or does not understand English or French, or, I mean, the employer has to go the extra mile, then train that person verbally. Ensure if they have any question, they can come back to the relevant contact point so that they are comfortable enough to say, hey, okay, yeah, go on. You can process my data. Is there any question that I missed?
No, I think you've
Yeah.
tackled all of them. Yeah, thank you. So,
Thank you so much, everyone.
yeah, thank you. Just to conclude, yeah. You earned your present. If there is an applause, there is a present.
Thank you.
Thank you. Let me just conclude by saying that maybe we're tackling it from the wrong part, these questions, because you can work poorly at the workplace, you can work poorly at home, or you can work excellently at workplace and excellently at home. I heard a saying, I will not say where, but the saying goes like, you cannot pay me as poorly I can work. And I think that the wrong aspect is labor relation is intuito persona relation. So it's very intimate relation. And where is trust gone? I mean, you can, as I said, work poorly anywhere or work good anywhere. So I think the trust and the relation between employer and employee has to be pristine in a way. So then you have no such issues. But thank you for this. Thank you for this session. And we continue in 5 minutes. Thank you.
All right, good afternoon. My name is Ingrid Dimo. I will be chairing the next session. I am, by way of introduction, the chairperson of the PSCBC from South Africa. And the next topic is entitled The Future of Work, the implication of digital transformation and hybrid work for labor law. And my colleague will be giving a perspective from Kenya. And in introducing her, her name is Cosima Wetende. She, by profession, is an advocate admitted by the High Court in Kenya. She specializes in civil litigation, arbitration, mediation, and also deals with issues of commercial law, employment law, defamation, to mention but few. She also has dealt with matters within the Court of Appeal and has acted as a counsel in various arbitration and mediation. The topic will touch, as I said, on the Kenyan perspective. I also will be encouraging you to keep your questions, your inputs or comments, as it were, precise and brief when we get to the comments and questions session. However, I am not intending to deprive you of an opportunity to engage with her. Ladies and gentlemen, shall we welcome Cosima to the podium?
Good afternoon, everyone. Great. So as you've heard, despite the very long topic, essentially what I am hoping to do is to give you a Kenyan perspective of what the whole discussion we've been having around digitalization, hybrid working looks like. I said the future because we are not there yet. I was happy to hear that countries like Mauritius are already a step ahead, and we have taken good notes on some of the issues that we would want looked into as legislation is being put in place in terms of digitalization and the work experience. So, okay. Yeah, so that's my heading right there. Right. So from this presentation, I thought I should give an overview of what to expect. And I looked into digitalization and employment, the interplay. What are the opportunities and growth areas? What are the gaps and concerns in that space for the employer and the employee? And what are the areas where there should be adjustment, alignment, legislation, regulation, and control? So I'm a social scientist in training, so I went back to data. And it looks like internet use in the world generally, from the indices that are set out there, is quite amazing. 5.16 billion internet users in the world. In terms of percentage of users of the total population, there's a 64.4%. Those accessing, I'll just pick various indices. Those are accessing the internet via computer and tablets, 65.6%. Percentage of users accessing the internet via mobile phones is 92.3%. You can see that the smaller devices have a larger use. So it's just telling us that in terms of the employment space, the numbers and the opportunities are quite vast. So I went into the background of how this whole discussion around digitalization has become the subject matter of a whole conference involving all of us here. And I think COVID-19 either accelerated it or made us see it clearer or give more focus to it. The labor market is getting more interconnected, it's virtual, it's getting digital, it's getting automated. And one of the issues that I thought we could talk about is this train going in a direction where it's going to stop and reverse, or is it going and going and going? Something to think about. The economy has also gone digital, or it's also going in that direction. And as a result, work as we have known it traditionally is evolving. It has evolved. There's a need to reorganize. The volume is amazing. It's the way it's growing. It's become so flexible that, as Georgina says, there's a category of young millennials who say, just give me the brief, give me the money, and then I'll deal with the taxman myself. In the workplace, including for us in legal practice, we went online. Conferences are online as such as this one. Meetings, people are working from home. The question of outsourced labor, I think we've also dealt with quite in depth this morning. It's quite a sticking point, but yeah, there's more outsourced labor, there are franchises, there are work agencies, and a lot of them are not just within Kenya, but also externally. We've talked about Uber and so on, those platforms where people are outsourced to work in various jurisdictions. In Kenya, we have seen a growth or emerging occupations and reorganizations, which nobody ever imagined people would talk about. Influencers, bloggers, you know, people would ask, what does my neighbor do? He's always in the house, but he seems to be able to pay his bills. So that's another perspective on this background that I'm going to look into. Of course, mechanization, the potential for job losses, you know, the regular routine jobs that have been taken over by actually artificial intelligence, or just by simple equipment, you know, like somebody who files the physical files for us as lawyers. Now we've gone digital, we're scanning things into the judiciary platform. So what happens to the person who was traditionally in charge of the filing cabinets? There's more flexibility. There are a lot of temporary arrangements. There are freelance workers. Yes, you're an employee, but you have 4 or 5 different jobs. That's a perspective that I didn't hear too much about today. We just heard about the downside of the digital platforms. But one of the upsides, at least from some of the Uber drivers I've spoken to, is that they have 4 or 5 jobs. One is a chef, and he does this, and he does that, and he does the other. I think as we look into the downside, we should also probably look at the liberation aspect to it. And of course, who is an employee? We've had that discussion all morning today. And then obviously the need to change legislation to guide and so on. So I looked into some definitions and categories which are now squarely in the employment space. You know, a digital economy. This is where all activities are digitized, the data, technology, infrastructure, and services. And I drew very heavily from ILO in terms of those definitions, because I think they've taken the lead in terms of running with it. Digital labor. Who's a digital laborer? This is a person who works using ICT generally. You know, as in if you're using ICT, or you're a digital laborer. So some of us would fall in that category, if not all of us. A digital worker is also well engaged digitally. And from the profiling from the ILO definitions, this is a younger person, more males than females in terms of working in that space. And I think that falls, I'll keep using Uber because I think other than for the people in Mauritius, it might ring true, right? Because I heard today that there's no Uber here. Yeah. Digital job, again, 3 categories. There are those who use ICT intensively. There are those who really just depend on it to get done what they need to do. And then there are those who ICT is used to enhance. They can do without it, but it gives them a bigger space to work with. So I am giving experiences based on the Kenyan perspective, which may ring true for some of us within the larger African context. So please, in the Q&A, feel free to contribute based on your own experiences. So from an employee perspective, in terms of the effect of digitalization in the workplace, some of the feedback that we have got positively relates to flexibility. Yeah, I'm flexible. As long as I deliver by the end of the day, I'll be fine. I can work from wherever I am. For young families especially, or people who generally want to stay put, you can work from home and you can balance your homely duties with your work and still deliver and get paid for it. So essentially you can earn a living. There's a category of employees who feel that I'm more productive because I'm in my space, I'm in control of my time, I will deliver better. In terms of expenses and time, I don't have to travel to the office. Nairobi traffic is crazy. So if you can wake up at 7 and be in your office, in quotes, in your study by 8:30, that works great. And obviously the travel costs, travel-related costs, and so on have been reduced or extinguished if it's full-time. The question of multiple jobs I touched on a bit earlier. People are able to do so much more and earn money from various different sources, which are diverse. I was told about somebody in IT who has 3 different IT gigs and just works. Basically full-time employee in 3 different organizations. So those are 3 salaries. I then looked at things from an employer's perspective in terms of the impact of this digitalization. And yes, there's flexibility, which rings true for both the employer and the employee. There's flexibility in terms of how and when things are delivered. But that obviously depends on the role that you're in, what position you play and so on. Because, for example, for us as lawyers, court went on the same way from 9 to 1 every day. So that flexibility component was not there. But for a lot of roles, as long as you are able to deliver, you had some room to determine when within certain timelines. Productivity, the feedback from employees and from employers is that, yes, there's definitely a category of employees who have been more productive. They deliver, they get things done. They are working harder, yeah? They are getting things done faster than they would have, rushing home at the end of the day at 4 o'clock, Now they can stay on a little bit longer. I don't know what your experience is, but for us in our office, we find that at lunchtime, a lot of people are still at their desks. So things that you'd have put down at lunchtime to go and do somewhere else, you have your lunch at your desk and just keep continuing. So there's a productivity benefit that the employer is feeling. Absenteeism, if you're working from home and say you need to do something that otherwise would have required you to apply for leave and so on, you don't necessarily have to apply. You can put in your earphones and drive to, if it's a school function, as you're driving to school, you're delivering. Yeah, so there's reduced absenteeism and more flexibility in terms of scheduled events. Employers are generally happier that they can, the surveillance and control is easier because if you have a gadget, if you're online, you're on a platform, people can see who is working, who is online, who isn't. We were in data privacy before, but that's really the feedback from employers. And then there was upscaling of skills and knowledge. You know, initially before COVID, when a client would send something and say you have a Zoom call, you'd call IT. We would call IT and say, okay, please, we have a Zoom call, set it up, call me when it's ready and it's done. But now we're doing a lot of these things for ourselves. Even this PowerPoint presentation, I would have had IT sitting there. I've done the paperwork, just do what's required. But we have upskilled, and have more knowledge about technology. So now the challenges and the concerns, starting with the employee perspective. So employees are working harder and longer. I talked about the lunchtime experience, for example. People are working harder and longer. If you work for an organization, which is, say, in the US and you're in Kenya, and a Zoom call is scheduled for 7 p.m. Kenya time, that would be maybe 9, 10 a.m. US time. You know, usually you'd be like, I mean, it would be so obvious that that is out of working hours that everybody would try and make sure that they are flexible. So the US person would say, okay, 6:30 in the morning. But now they'll say, no, 8, 9 is fine for us because you have your gadget with you. So people are tending to work a little bit harder and longer. And I think that relates to the second point. There is a degree in which the initial excitement post-COVID has reduced a little bit. People are feeling tired. You have your office with you all the time. It's just with you all the time and you get to know what's happening. You might not read the emails, but you'll see them coming in. And then you begin to feel the pressure as the weekend is coming to an end. Then interaction and collaboration. We are social beings, and you know, people's home situations are diverse, they are varied. There are people who have a lot of people in their houses, there are people who don't have people, they live alone. So you may find that that people are realizing that, gosh, it's been a week, I haven't left my house, I haven't spoken to anybody, I haven't done this. And so that close interaction and collaboration that happens within the office has a social and a mental benefit, which has diminished, but the less one actually goes into the workplace where there's more interaction. Impersonal and invasive, you know, in the sense that you're sitting in your house, in your nice, vast library with all these things and everybody's seeing it, but you don't realize that it's giving a picture of actually how you live. So you may find also for somebody else, you're in a bed sitter, you're a great employee, but you're quite happy to live in a bed sitter. And when you put up your gadget and you have to take time to put a picture behind you so it looks, or you block it up as people do and change the background. So there's a sense in which there is a bit of an invasive nature. I'll also deal with that under the health and safety components, where earlier, as you heard, the employer has a duty to establish that workspace is actually safe. So I've dealt with mental health, fatigue, isolation, depression, lack of motivation. I don't want to gloss over that, though I tied it in with fatigue because that has become a great a concern. There's a lot of that happening where people used to look out for each other. It's not as much because people are not as close. So somebody can go through something for such a long time before the people around them realize that there's a problem. Physical health, particularly relating to sitting for long hours on the wrong sitting thing, I'll call it thing. So because some people do their Zoom calls on the sofa, lying back, and you just put your laptop facing up or your phone. And there are those also who sit on chairs which are not built for long hours, your dining chair or, you know. And then, of course, there's the concern of potential job losses from those administrative roles, particularly the ones that have been taken over by artificial intelligence. For the employer, from the employer's perspective, in terms of challenges and concerns, I had talked about the environment, health, and safety compliance. The employer in Kenya has a duty to make sure that the workspace is safe. And now when the workplace moves to my house or to an employee's house, then in order to make sure or to cross-check whether the place is safe, as we had earlier, the employer has to come, do an audit, get you to sign, and you know, those boundaries are crossed to a large degree, but that employers are having a difficulty meeting that requirement. There's a court decision where there's a gentleman during COVID in one of the European countries, during COVID, tripped when he went to get coffee. And from the reporting online, he got damages because he was at work and the workspace was not safe. So those are some of the real implications of what it means to adopt either a hybrid or a working from home arrangement. Work policies, contracts, and so on really need to be reviewed with this arrangement in mind. And it's such a flip from what was envisaged that the employer has the responsibility now of recalibrating literally most, if not all, the policies that we touch on where people actually work, on the place of work. The employer also wants to interact and collaborate with the employees on things. When you're walking in the corridor and you meet your boss and they say, you know, Cosima, please come see me on this. There's this new thing and so on. You know, there's this case, this judgment I got, you know, or something like that. That is missing. So there's a sense in which some silos are coming up in the workplace, which has its downsides in terms of working together with one vision, one mission. Employers are wondering what to do with their office space. They've realized that people can work in really small offices, and also if a large part of the workforce is working from home, do you continue paying rent? What do you do? Is this arrangement going to go on? Do we need to have a strategy meeting to make a decision? I know for a lot of these huge tech companies, some have been recalled back, at least for a hybrid option. I want to deal with selecting roles, supervision, and management together. You know, calling up your supervisor, making sure that they are free before you're able to consult or engage on employment-related issues can be a bit of a pain, because it sets up a formal structure, while before you'd walk into somebody's office and say, okay, I'm doing this, what do you think? And you discuss and everybody moves on. So it does slow things down a little bit. In terms of the company culture, the corporate culture, the formality or informality of the whole digital space, that I think speaks for itself, because most corporates have a culture by which they operate. This is how we do things. We have an open door policy, yeah? But you can imagine for somebody coming in as a new hire from another corporate, and on his first day, he's introduced on Zoom in the morning, hi, and then he's given work to do. So he doesn't really, it takes a while, if at all, for them to pick up on what the culture of the organization is. And finally, because yes, we are a third world country, in terms of the number of people who would be digitally skilled, there's definitely a shortage. There's definitely a shortage. I didn't put on the slide, but I also wanted to bring up immigration and data protection. Data protection, I think we've discussed in great length. But from an immigration perspective, you have somebody who is sitting in Kenya, working for a US organization, doesn't have a work permit, is going to become a resident when the number of days reach. You know, there's a sense in which if immigration were to open up some of those issues, it would create a huge risk in terms of breach of the law on immigration. So those arrangements that seem, fluid, not to have any impact, would certainly have an impact. And it is the duty of the employer to collect taxes. So if the taxman comes and says, no, this person is an employee, is a resident of Kenya, should have paid taxes, then the obligation falls on the employer to take care of that with all the penalties. So points to ponder in terms of those competing interests that I have tried to illustrate from really a practical experiential perspective. I want to say that I don't believe that the conversation around the workplace and digitalization and the rights and the duties is something that can be done without the government's support, involvement, and so on. Because when the government takes the lead, then the questions of legislation, you know, the framework, the regulations, how will we do this? How will we do immigration issues and so on, then becomes very, very clear. From my end of practice, what tends to happen, and I think even from the discussion here, you have these platforms that come into a country, they've got a legal opinion from lawyers on what it takes to operate in that country. You know, they'll ask you, can you do this? Can you do that? And you say there's no legislation, there's no control, there's none of that. Then 2-3 years later, somebody files a case and you have told this platform company that these are not employees. And then the court says they're employees. You know, there's a sense in which in order to do business and to thrive our economy, there's a need for certainty. There's a need for things to be certain. When you come into a country, you're going to be an employee, whether you do this or not, whether you're on a platform or not. So government is a key stakeholder in terms of achieving any form of clarity around how and where we hope to go. Yes, the government is trying, you know, discussions are ongoing, but we are not there yet. We don't have a policy. We don't even have a draft yet, at least as far as I know. So if there's any room to contribute, I want to thank the Mauritius team for the input that they've given us this morning. Something else to ponder, we spent quite a lot of time talking about the Ubers and so on. But maybe we should spend a little more time also looking at local innovation so that we have local solutions. We won't have to worry about a lot of the issues that we're talking about today in terms of is it a foreign company, who's the employer, you know, and so on. If those problems are localized, I'm sure even the solutions will appear simpler for us, you know, within the Kenyan context, within the African context, and also to incentivize and support platforms, people who are able to come up with ideas, novel ideas, in order to localize the discussion, so that, you know, it does make it easier to come up with your own solutions to these problems. Now, we are some steps behind on the digital transformation space. I think we are a little bit behind. Things get to us just a little after they get initiated in other countries, but they do get to us eventually. And so there's a need to catch up. You know, you're kind of catching up. You have your Uber comes in 2 years later, they set up in Kenya. Yeah. So we would like to catch up digitally so that our policy and legislation is as current as it should be. And we are not taken by surprise and led by precedent from other jurisdictions where their experience may be different. Education and training is an area that I would say I'm a little bit passionate about, because our education system and our training system is not quite fully digitally aligned. And I would like to look at it from across the whole country, not just as an elitist perspective. We really are not in a space where even the discussions we are having today maybe would affect maybe 10-15% of the population. So we would want to build capacity, train on what needs to be done. Again, the government support would be key in that. I talked about a hybrid model with a middle ground, because a lot of the challenges and concerns that I brought up earlier can be surmounted if people are in the office a little bit and at home a little bit, you know, working from wherever they are on and off within specific parameters. Yeah, inequality of resources and access. You know, for example, you know, in the rural areas, if one went and started talking about data protection and digitalization, I mean, they just will not relate. That is actually the reality of what it is. So that as we legislate now, as we plan, as we discuss, we need to know that we are leaving out a big part of our population. And obviously there's a cost component, you know, economically, what size of our population can actually afford data? to even get involved in some of these platforms that we are dealing with, or like you saw initially, the statistics, it's the smartphones that are used more than the laptops. There are certain things that you're limited from doing on a smartphone vis-a-vis a laptop, in terms of opportunities also out there in the digital space to make money. So that is really what I had to give you a feel of what the Kenyan experience is, what challenges there are, what opportunities there are, and also to generate discussion around what are the things to ponder, to consider as we have these huge conferences where we talk about these things and the impact of those who are actually the majority in the population. Thank you very much.
Thank you very much, Cosima. Come and sit next to me. Oh, I think the presentation was equally aligned to what was earlier discussed by the previous and some of the challenges that you touched on. We do experience them as professionals, whether be it in the legal profession or otherwise. Of course, we do experience them. I'm hoping, despite that, you will be in a position to take questions, right? I know that some of the questions were answered earlier by our colleagues, but you will be able to take some questions, right? All right, we will take questions. There are roving mics in the room. We'll take a few questions before we take a tea break or leg stretch break before our next session. If there are any questions, please do raise your hand. And also, as we did with the last presentations, do indicate your name, your organization, before you ask a question. Thank you. Over to you, sir.
Hi, good afternoon. My name is Walid. I am the legal counsel for the Ecloser Group in Mauritius, but a Kenyan at heart, so Abaragani. My question is relating to with the advance of hybrid working globally. Do you foresee that it will become harder for corporates to instill a culture of, for corporates to instill the corporate culture and also to instill a corporate identity into their workforce? Thank you.
All right. Next question. Any? The middle row. Okay, in front, Vice Chair.
Thanks. My name is Cosima from South Africa, PSCBC. Chair of the session. But just one question, or just one to be convinced in terms of, and particularly on the opportunity. For both the employer and the employee, particularly on the issue of product. That's it here. I don't think it's coming to come back. Very few employers will say we must work from home because they've seen that whole process was something like a contract. It was not so productive. So I don't know how Kenya they are measuring their productivity on the whole process. Because what I know is many of the meetings that we held Chair could not reach or cannot include on the basis that someone will just, you see, there were a lot of things. And there was also a lot of absenteeism on the same matter. That some comrades or some what is it? Employees will just connect and say 2 minutes and say problem of connectivity, then he goes to town. So I don't know how really do they measure productivity. Even now, seated here, we still experience the same problem or the same, we still have the same experience whereby such kind of meetings could not even reach conclusion based on a number of things which are man-made, not that there is no resources, not that there is no electricity and whatever, but just because it served the whole process had a lot of hide and seek. Thanks, Chair.
Thank you very much. One last question. I'm very accommodative. You can misuse me while you still have a choice to do so. Okay. All right, Cosima, I think those are the two questions, if you may, over to you.
Thank you. I'll start with the last one. In terms of productivity, that is measured in terms of what the company hopes to deliver. So if it's a financial institution, when they are balancing their books at the end of the year, they're quite happy. They are like, oh, this is working. Because like during COVID, with the shutdown, there are people who are still trading. It was not quite as it should have been, but this is now after COVID. And I think as a balance, a hybrid work arrangement, which seems to be the direction things are going in now, because it's really more hybrid now than it is fully working at home for most sectors. Productivity has actually gone up. People are ticking those boxes. Was this done? Whether the people have gone to town or not, when they come back, they actually get done what needs to be done. If you're going to town, you've chatted with somebody and said, I've gone to town, just let me know what I'm meant to deliver on. So I guess there's some innovation, but I think I'm talking about it more from a numbers perspective, from customer satisfaction and so on. In relation to the question about what my view is on the future and a hybrid working arrangement coming up or taking root, I think it's more likely to go in that direction. To relate it to corporate culture, which was actually the specific question that was asked, I think within the hybrid space, if a corporate is deliberate about who they are and what they are doing, I think there is a higher chance of embedding the corporate culture than there would be if people are just working from home. We put on our best faces when we have a screen in front of us. So if you really want to know who I am, just come and find me in the office on a bad day. So yeah, I think that covers the issue. There's hope within the hybrid space.
All right, any follow-up questions? Going once, twice? None. All right, thank you very much, Cosima, for your presentation. It was very insightful.
Thank you very much.
I've also been requested to hand you a gift as part of appreciation from the colleagues. All right, thank you very much.
Thank you very much. We are now moving swiftly to our next session, and the topic will be on the clauses on labor law and activities of the African Development Bank and the other development aid banks operating in Africa. The speaker for the day or for the afternoon is Mr. Benoît Lopez. By way of introduction, Benoît holds a master's degree in human rights. He is also a holder of master's degree in labor law. He is a lawyer by profession, specializing, of course, in labor law, and was the assistant professor at the University of Renault. Before, yes. And he is also a teacher or teaches at the University of Paris Saclay and for the Versailles Bar Association. I hope I pronounced it correctly. All right, ladies and gentlemen, please help me welcome Benoît to the podium.
I'm gonna keep this.
Thank you so much. Hi, everyone. Thank you so much. First of all, I want to deeply express my regards and for the staff of the fifth conference. That was a great pleasure and an honor to be here and to see many colleagues and practitioners of labor law from all around the world. So I feel really grateful to be here with you this afternoon. So thank you for the invitation, and my pleasure to talk about one of my previous subject of research and one of my favorites, to be honest, because part of my PhD thesis is about social clauses. So in Africa field of economy, you have obviously the African Development Bank. We do the country and the regional most important role to serve the development head proposition. But as you know, you have sub-regional or national bank. They also try to do aid programs for development. To start with with recent news, in May 2022, the African Development Bank launched consultation for the update of its integrate safe system. This was an opportunity to see the first proposal for modification with its integrated safeguard system. Why I'll talk about that? Because for labor law perspective, the opportunity to have conditionality in the development aid program is very important. Because of conditionality, you can say, okay, you got my money, but you can just take the money. You have to take some step forward. You have to take some worker condition improved. You have to take some serious legally binding proposition. And it's all the subject of my conference today. It's because, in my opinion, development aid can be a really, really strong champion to challenge difficulty of the African and all over the world labor misconduct in the world. So, like I said, 2022, African Development Bank start a consultation. I'm sorry because we don't have the final cut and the final draft of the consultation. So in few minutes, I talk about it, but I cannot imagine what's the final result. I hope in a few months we got it, but it's you can already see that because the first one was 213, sorry. So you can see it's still a news and it's still the necessity of improve safeguards, because for the development bank, you had to reimagine again and again the conditionality about labor work, about labor law, sorry. So another news is from the West African Development Bank, not the African Development Bank. They start to imagine that type of safeguard framework for the aid in the UOMA. And they ask to the African Development Head if they can help, because they don't necessarily have the technical expertise to imagine safeguards about labor and environmental law. So as the result of this consultation and this technical assistance, they have new safeguards and policy safeguards when you have to require aid because you are a corporate or public sector actor for the West African Economic and Monetary Union Bank. One of the key issues of this new policy is strategic and operational mainstreaming framework to promote gender equality, gender empowerment within the investment and the portfolio of program. The key issue stressed by the consultation is the bank had to work in several fields. The main field are working condition, obviously, pollution prevention and management on rational use of resources, water, for example, community health, safety and security, but also land acquisition, restriction on access and use of land, and involuntary resettlement. So, as this type of list, you can hear that I spoke about labor, but I spoke about environment. Environmental issues are one of the, for me, the first problem is you can think development aid, labor law, without thinking about environmental issues. Why? Because when we look at the development of the policy of African Development Head or the World Bank, the group, you already can see that environment is a big part of labor law progress. I talk about that in a few minutes. So to keep it with the introduction, first thing to understand is when you talk about labor issue, you cannot just talk about state regulation. And I'm really, I don't know if she is still here, but I heard the conference a few minutes ago, and I'm absolutely okay with what was said. You don't just ask for state regulation because it's certainly, and you can know, oh, okay, I have this type of regulation, and when I am a corporation, I need to know what kind of labor regulation I will face. You also need to think, as a corporate actor, what is my part of this development in this country? What is my part in labor resolution? So when you talk about social conditionality of aid, you have to think about state regulation and corporate regulation. But when you say that, that not mean auto-regulation, that don't mean only corporate social regulation. It means draw a frontier, but you have to work together as a state and as a corporate. For example, thinking about social conditionality of development aid implies thinking in an integrated way between aid to public actors, public sector, as well as to private actors. Just one example, when you have to build an hospital, when you have to build a road, you can just manage it with public sector. You have to get private sector, you have to improve private employment. And for that, you need to think integrated way. Second issue I want to stress in this introduction is the transition from the improvement of worker condition to labor law. States, as well as companies, trade unions, and NGOs have a common and inseparable role to play both in fighting for better working conditions and in ensuring that these changes are legally binding. My conviction is that changes for workers must, at some point, be able to be sustained by the improvement on rights in an official way, and then of their respect. A few hours ago, we talked about enforcement and the thing that it's not sufficient to talk about. We got law, we need to enforce law, and it's a key issue. I totally agree with that, about that. When countries refuse to move forward, for example, because dumping social is one of a way to attract foreign investment, when a company refuses pleading self-regulation as in corporate social responsibility, it is a bad sign. You have to accept to move forward, to go from improved legal worker condition to legally binding law, labor law. Then the other aspect that I want to address in this introduction is the condition, the elements that can, in my view, facilitate the advent of a better conditionality of development aid based on labor law. Here again are the two factors, one more obvious than the other, but both worthy of analysis. Because first factor, like I said earlier, the environment. Because of concept as sustainable development, corporate social responsibility, and the current dynamic of sustainable finance, labor is being brought in as a third pillar with the environment and the economic one. I think you already all know the third pillar of sustainable development. So I pass on that. I will come back on this later in my analysis of the African Development Bank's integrated safeguard system, but clearly there is what I called, and when we call a pull effect in favor of labor law, thanks to the progress of environmental issue. The current work of the International Labour Organization on sustainable growth is evidence of this, as is the European Green Deal in terms of the taxonomy of responsible finance. So ILO speak about green job, speak about economy drive by the environmental issues. When you speak about politics in European Union, we speak about responsible finance. It's the same way and the same kind of thinking that you can improve labor employment level, labor condition with an environmental perspective. However, this poses a difficulty that should not be denied. In sustainable development, there is the idea of a sustainable economic development. However, the economic pillar, the historical model of growth, in particular, the creation of low-skilled jobs, export agriculture, or the exploitation of the subsoil by extractive activities are in contradiction with this vision. You can have both, in my mind, and you need both, because from an Occidental perspective, when you are in the United States, when you are in Europe, you can say, okay, so we need to improve the quality of the economy perspective because we have sensitive issues, sensitive regard of environment. But when you are a less developed country, you have to develop, first of all. You can talk about transition when you don't enough development. So how to solve this tension for development aid by ensuring the fastest possible economic growth as it necessary, while requiring not only respect for the environment, but also for work. The answer may be the creation of green jobs and the development of new sectors. Yes, it can be. But an approach that is interesting and deserves to be completed by, in my view, the one developed by the Long Times Bank for the selection of a project, and they call the best in class. From this point of view, I think that focusing on helping companies and public sector activities that integrate social and environmental concerns is a balanced approach today. Also, in few words, what is best in class is, okay, everyone cannot be all the company in a sector, all the company in a country can be labor and environmental driven company. They can all focuses of try to be a better economic actor. But at some point, one, two, few companies can afford it, can try to do better in environmental and labor perspective. So they are the best in class, and they are chosen by the development bank, by the sustainable investors in finance, the venture, for example, the impact investors, to be helped. And I think is the more reasonably thinking about development aid in labor conditionality perspective. So first factor is environmental. Second factor that can improve labor conditionality in development aid program is the fight against fragility, violence, and conflict. This type of wording is from the World Development Group. The COVID-19 pandemic has shown, particularly on the issue of work, important difficulties to respond at the level of state or of certain cities or regions to the difficulties that is posed. In these circumstances, the development aid strategies of several large development aid organizations have taken into account the social issue in their support for institutions to strengthen them. The link here is less natural than with the environment one, but it is worth considering, as we will see, with the policy of the International Finance Corporation of the World Bank Group later on this conference. But to re-emphasize the tensions that can exist, issue of labor immigration, for example, or business interruption due to the pandemic necessarily impact political structure. That's why the program about
fragility, it's institutional fragility mainly, violence and conflict of the World Bank can be interest, labor conditionality and development aid. To give the most obvious example, work without a contract will cause problem for public structure to collect taxes. Then, the impossibility to work due to the lack of a sanitary response to a pandemic will increase the risk of political destabilization, especially in case of famine. Finally, migration can also involve administrative management, which can be a source of difficulty and institutional fragility. I will therefore look successively at the place of the environmental as a lever for social conditionality in the African Development Bank approach, and then in the second part of this intervention, then I will return to the World Bank strategy around the issue of the fight against fragility, conflict, and violence, and in what way that can help labor law. So, first thing, improving social conditionality for the environment. First, the African Development Bank adopted an environmental policy in 1990. At this point, we don't speak about labor issues, we don't speak about employment issues. It's just environmental one. Subsequently, the bank developed safeguards policy on involuntary resettlement and the environment. It has also developed action on cross-cutting issues such as gender, climate risk management, and civil society participation. Thing is here is they talk about gender, but only as a political or a human rights issue, but not as a labor law one. However, these different policies frameworks were not initially conceived as a comprehensive system for conditioning economic aid in the name of sustainable development. On the other hand, a first step forward was nevertheless taken with the adoption of environmental and social assessment procedure in 2001. So, it is a labor issue. However, this change between the purely environmental approach and the addition of a search for a social dimension was again achieved by reference to the sustainable development. Nevertheless, it is only then under poverty reduction that the social aspect of sustainable development is considered. Thus, following the creation in 1996 of the Environmental and the Sustainable Development Unit in June 2001, the bank's board of directors approved a new organizational structure. This new structure will result in the transfer of the function of the Environmental and Sustainable Development Unit to the Sustainable Development and Poverty Reduction Unit. So they can look like just as an administrative denomination, but that prove in a way that they don't only think about environment, they start to think about poverty, about social condition. Despite the absence of mention of labor condition as a separate issue, the new policies provide the basis for the bank's future environmental and social safeguards. Thus, the turning point will come in 2013 when the bank adopts, finally, an integrated safeguard system which explicitly refers to the treatment of workers for integrated safeguards number 5, which address the theme worker condition, health and safety. That was the first strictly labor clause. The adoption of this clause is intended to establish the bank's requirement of its borrower or clients with respect to workers' condition, rights, so you have the two elements, the condition and the labor rights, and protection from abuse or exploitation. The clause is based on the standard and definition adopted by the ILO. I don't know if he still here, but so sorry, it's ILO as the key role to improve labor standard in the politics of development. In the area of working condition, worker organization, occupational health and safety, and the prevention of child and forced labor. But it should be noted, however, that unlike the World Bank Group, for example, the African Development Bank makes the reference to international labor standards, but not directly. I explain. It is envisaged for formulas that reduce the scope of this reference by introducing a subjective assessment of the equivalent of national law. So you don't have to tell, I comply with international labor standards. You can say, okay, my national standards is as good as ILO convention. In some countries, when you don't have ratified ILO convention, that's a problem. I heard early this morning that Mauritius have already ratified the 190 convention. So it's a good thing here at Mauritius, but it's not the same all around Africa, all around the African nation. So, and part of this nation really don't want to ratify the ILO convention. So it's in kind of this situation, just said, okay, I don't want to ILO instrument, but my national law is as good. It's not really a small problem. So beyond this, it is once again the state objective of promoting sustainable development that will allow the adoption of this new social clause in the wake of the environmental clause. This relationship is explicitly stated in the first operational safeguard. So I quote, the objective of this overarching safeguard and all the safeguards that support it is to integrate environmental and social consideration, including those related to vulnerability to climate change, into the bank's operation and thereby contribute to the sustainable development in the region. So, like I said a few minutes ago, normally we have in 2022 a new safeguard policies and I hope new social conditionality, but they are not issued yet, so we have to wait. And if you look about the preliminary draft, you can have access on it because the bank start a public consultation with shareholder and with interest public. You can see, and it's maybe a talk about Uber worker and platform worker can be rethinking in this light. The scope of application of the safeguards policy will depend on the type of employment relationship between the borrower and the project workers. And the thing is interesting is there are 4 types of project workers, project as a bank development aid project. And the 4 type is people employed or engaged directly by the borrower, including the proponent of project activities in the implementing agencies that carry out projects, activities, or other initiatives to work specially in relation to the project. That's the bank called direct workers. Second, people employed or engaged for third parties to perform work related to core function of the project, regardless of location. That's what's called the contracted workers. And to stop it 1 second, in my mind, when you have Uber, when you have platform workers, it can be analyzed as contracted worker. So the problem is, it's not the same amount of aid and it's not the same aspect of the aid development when you just try to add transnational corporation. In my mind, it's less efficient, but we can have the talk about that. And when I run out of time, I speed up. People employed or engaged by the borrower primary supplier, so it's called primary supply workers. I think it's an absolute necessity to apply conditionality and labor conditionality rights for this type of project. And finally, community worker. It's pretty interesting one because in the African development aid perspective, community worker are those the community can work on, the community can work free as a volunteer, but it's because they want to help the realization of the project, for example, a school or an hospital. To finish, and I've got 2 minutes left. Yes, okay. To finish, the second factor I already speak of is the fragility, conflict, and violence. So the World Development Group and is one of the part of the activities, International Finance Corporation, start an Africa Fragility Initiative. What the point is for this special initiative is to support development in fragile and conflict-affected situation. And in 2022, EFC launched this initiative with 74 million ways as a 5-year program established with the support of Ireland and Norway. So, is it a room for labor law in institutional fragility, conflict-affected situation, or violence situation, and for the social conditionality? Alors, I step up at one example for conclude. For me, one of the best examples of why the World Development Bank and the sushi of fragility, politics fragility and the conflict-affected country can be a driver and a new driver for social conditionality is the Somalia Urban Resilience Project. On the second phase of this Somalia Urban Resilience Project, financed by the EIFC, with al-Shabaab still in control of part of the country and attacks frequently targeting government, strategic infrastructure and people in urban areas, the clear provision, as a demand of the World Bank, provide under labor working condition, community health, and stakeholder engagement. This has helped to address security risk for project workers, such as putting in place restriction on work hours and access control to construction sites, the host community, such as management of risk from the use of public security force, and to finish, public stakeholders, such as the use of low-profile focus group meetings and individual interviews rather than high-profile public consultation. The government has committed to implementing this measure in the environmental and social commitment plan to get the development aid. This example on the Somalia Urban Resilience Project illustrated for me the difficulty to work without state when you have a conflict and a war on the country, obviously, but it's kind of a hope because you can see when you have some issues, when you have some armed conflict still in the country, you can try to make better place for workers with the Development Aid Bank. Thank you.
Thank you very much, Benoît, for your presentation. Colleagues, as I indicated, Benoît's presentation was mainly to touch on the legislative provisions regulating the activities within the African Development Bank within the context of Africa, of course. And I suppose, Benoît, much as there was no official presentation in terms of the written format, he will be in a position to take questions from you on the examples that he has provided on the aspects emanating from the legislation itself. I will take a few questions and give him the opportunity to respond, as it were. All right. Any questions on the far right part of the room? None. Middle row? You have one question, Kumoy? No, you are covered. Okay. The far left? Covered as well. All right, Benoît, thank you so much for your presentation and for also having shared the information with us. As you did, we really appreciate it. Okay. All right, colleagues, let me also take this opportunity to thank you for having been part of the session under my chairmanship and having interacted with the discussions as you did. Also from the PSCBC point of view, I wish to thank the ALLS for having afforded us the opportunity to be part of the program and also to participate within the context of our role as a sponsor to the sessions. ALLS, we wish you all the best for the remainder of the conference. And colleagues, the conference is not yet concluded. There is another session that will follow shortly. And with that, that concludes my role for the day.
Good afternoon, everybody. I think we should start off by giving ourselves a hand of applause for still being here. Well done. Because I do think we are going to have a very useful and very interesting discussion right now. But let me first of all introduce our speaker, Nicci Whitearnel, and she's going to talk about labor dispute resolution using video conferencing facilities, and then universal lessons for Africa with a focus on South Africa. Now, I've known Nicci for very many years. She's a seasoned labor law specialist in South Africa. She's a senior lecturer at University of KZN, Pietermaritzburg campus, where she lectures in two fields, adjoining fields, labor law and law of evidence. And that's where her interest comes from, is the law of evidence and the labor part put together. She has been a CCMA commissioner for the past 22 years. It's almost a lifetime. And she is a senior commissioner of the CCMA. And she has conducted virtual CCMA hearings herself. So without further ado, she's got about 30 minutes for her presentation part. Looking forward to your presentation, Nicci.
Thank you very much, Stefan, and thank you, ladies and gentlemen. Yes, it is the graveyard shift, but I'm nevertheless very happy to be here and happy that you are too. Thank you. I won't slow you down for your cocktail party too much. I first of all also want to thank the Society, of course, for inviting me to do this presentation in the first place. I do consider it an honor. Okay, yes, so Stefan has introduced my topic for me. And sorry, I just want to make sure my slides are going to show up. With the black button.
The green one.
The green one, okay.
Just activate it again. Your own
yes.
there as soon as they. And then for the rest, it's just add one. If you want to use the laser.
Okay, thank you. Thank you. Yes, so Stefan also told you that I'm from UKZN, not as far away from Mauritius as some of you are from, but a fair way away nevertheless. So let me commence. The South African model for labor dispute resolution is provided for by the Labor Relations Act, and it's quite well known. It served as a model for labor dispute resolution institutions and processes all over Africa. I won't mention all of the African countries that have adopted at least some features of the South African model, but I'm sure you're aware of some. So for those of you who don't know, the South African model of labor dispute resolution operates around pre-conciliations, conciliations, and then if the matter is not successfully resolved at conciliation, it'll be finalized either by arbitration by the CCMA or a bargaining council, adjudication by the labor court, or if it's a dispute of rights, it'll be finalized through industrial action. These type of, my presentation is going to focus on disputes of rights, which will be finalized by way of arbitration in the CCMA or adjudication by the labor court in the event that they're not settled at conciliation. These type of disputes would include dismissal disputes and unfair labor practice disputes, which are by far the majority of cases that are referred to the CCMA. But I'm also going to be covering labor court trials, reviews, appeals, applications, and so on. So to start with the pre-conciliation process, Rule 12 of the CCMA rules deals with pre-conciliation. And what happens with pre-conciliation is that in the 30 days immediately after a matter has been referred to the CCMA, a CCMA official will telephone the parties and make attempts to try and settle the case. I mention this because to indicate that trying to resolve matters amicably without a face-to-face meeting is not new to the CCMA. And in fact, the pre-conciliation process is very successful and resolves a very significant number of cases even before they reach the formal conciliation phase. And bear in mind that this is within the first 30 days after referral. So it's a really quick process. And this is interesting. And the reason that I'm highlighting this is because across the globe, if we look at international experience, there's been a tendency all over the globe. I focus particularly on Australia and India, but all over. Courts have often been reluctant to allow people who are involved in cases which need to be reconciliated. The courts have been reluctant to order that they can do that virtually or remotely. They've insisted that it be done face-to-face. And the reasoning is that when there's a need for reconciliation, it's easier to achieve reconciliation in a face-to-face process. There's a fear that the rapport necessary for settlement might not be achieved if it's done virtually. I'll come back to that point in a while. Well, prior to the COVID pandemic, the Labour Appeal Court had even approved of a commissioner taking evidence from a witness in a case involving significant disputes of fact from Australia via a telephone link, not an audio-visual link, just a telephone link. And this was the Simmers-Campbell Scientific Africa case regarding the fairness of the dismissal of a senior executive for sexual harassment. Simmers was called to attend a disciplinary inquiry, and he was facing a number of charges, including sexual harassment. He was dismissed, and he referred a dismissal dispute to the CCMA. The victim of the sexual harassment was an Australian citizen, and she had gone back to her home country before the arbitration. So that's why she was testifying initially by way of an audio-visual link via Skype. During the arbitration, the video part of the link failed, and so she was testifying only via a telephone link. Bear in mind that this is in a case where it was basically a he said, she said scenario. The employee, Simmers, complained that she had had the benefit of delays, pauses, broken connections, and time to compose herself and think of answers by virtue of the lag in the transmission of sound between the two countries and the usual kind of technical glitches that you sometimes find with these kind of link-ups. He also argued that it wasn't fair because he hadn't had a chance to face his accuser and that he would have been able to get her to make certain concessions if he had been able to cross-examine her face-to-face. And he emphasized that this was a case in which demeanor and credibility would have been especially important because, as I said earlier, it was a he said, she said scenario. He lost the case at the CCMA, and the matter was then referred to the Labour Court. It was taken on review. Steenkamp J was, the late Steenkamp J was the judge who heard the matter, and he was okay with the fact that she had given this evidence only by way of a telephonic link. So I mentioned this case, although it's a pre-pandemic case, to illustrate that the idea of having digital or remote or virtual hearings is not all that new. It is something that we are used to. But with the COVID pandemic, of course, there came a need to formalize the process in terms of which evidence was being taken digitally or virtually or remotely. And so processes, particularly arbitrations at the CCMA and certain bargaining councils and labor court matters, especially reviews and applications, began to be heard on by way of video conferencing rather than in-person hearings. In this milieu and with this group of people, it's probably hardly likely that I need to define video conferencing. But just in case, it of course refers to a situation where the commissioner and perhaps one of the parties might be in one location, another party will be in another geographic location, but they'll be linked up in almost real time by way of technology. Platforms such as Zoom, Microsoft Teams, Skype, there are lots and lots of different ones across the world. The CCMA has chosen Microsoft Teams as their platform of choice. And at the CCMA, a consent form was drafted. And it was initially understood that consent from both parties would be necessary in order to have a virtual process. I've got the terminology up on the slide. We sometimes refer to these processes as processes being conducted via video conference. Sometimes they're spoken of as remote processes, virtual processes, digital processes, online processes. And then the term hybrid process is used to refer to a situation where the commissioner might be physically present with one party, but the other party might link in via a video conferencing platform. Or both parties might be with the commissioner or the labor court judge and a witness gets linked in via video conferencing tech. So initially, sorry, if I could just recap for a moment, initially there was this consent form and the idea, the understanding at the time was that both parties would have to consent to a virtual process, otherwise the matter would be postponed until after the pandemic. What happened, though, was that commissioners seized upon Section 138 of the Labour Relations Act. And even where there was one of the parties who objected to having a video conferencing hearing, the commissioner would seize the power given to them by Section 138 of the Labour Relations Act, which gives the commissioner the power to conduct the arbitration in any manner he or she deems appropriate, as long as they are arbitrating the matter fairly and speedily and with a minimum of legal formalities. So what commissioners used to do is they would listen to the arguments for and against video conferencing, and then in terms of Section 138, they would make the appropriate ruling. And this is still the situation, even though, of course, the worst of the COVID pandemic is over and lockdown restrictions no longer apply. But even though some parties have become very au fait with virtual hearings and very, very comfortable with virtual hearings, there are still people who feel very uncomfortable with it and who object strenuously to conducting a process remotely. Nevertheless, statistics from the CCMA show that online hearings remain fairly common. So for the first period, this was during the heat of COVID, 1st of April 2020 to the 31st of March 2021, there were 2,567 online cases conducted. From the 1st of April 21 to the 31st of March 22, there were 3,872 online cases conducted. And then from the 1st of April 2022 to the 31st of January 2023, there were so far 2,070 cases. There are imminent amendments to the CCMA rules. We expect the new rules to be published in about a month's time. And one of the rules that's going to be quite significantly amended is Rule 24. And Rule 24, subsection 2 to be specific, is going to remove any possible understanding that there needs to be consent between both parties before the matter will proceed on a remote platform. Because Rule 24.2 is going to say that a commissioner will determine the venue for a hearing, which venue might include an online hearing held via a digital platform. The CCMA is also planning to pilot an e-commissioner project, And an e-commissioner is envisaged to be a commissioner who works on a paperless basis without provincial boundaries. And the e-commissioner will be someone who works exclusively on an online platform. And the idea is that they would be this like a roaming commissioner, but not physically roaming. If a dispute in Cape Town needs to be arbitrated and the e-commissioner is available, the e-commissioner will pick up that case on a remote basis. If there's then a case in Durban that where the parties are waiting and the commissioner finishes the Cape Town matter, that e-commissioner will then pick up the Durban process. The director unveiled the e-commissioner plan only last week. Actually, it wasn't even a full week ago. It was a couple of days ago that the director held a meeting with the commissioners of the CCMA and announced this plan. And the director of the CCMA actually said that he envisages that the future, I'm not sure how long-term he was thinking or medium-term, but he said the future of the CCMA lies in the e-commissioner idea. In future, he alluded to his idea, his vision, that most processes would be conducted online in the future. So it's possible that the numbers that we saw on the screen earlier are going to increase dramatically. Well, they're definitely going to increase. Maybe they're even going to increase dramatically. You might be wondering, how's the CCMA going to be funding this? The CC imagines that the money it saves on paying commissioner travel costs, particularly to the far-flung rural areas, that money is going to be saved and will be spent on Wi-Fi and uninterrupted power supply devices. The CCMA is also liaising with local government, the Department of Employment and Labour, NGOs and churches to use their premises and facilities to enable users who might not have had access to devices and data to connect with the CCMA from those facilities and those rooms. It's also anticipated that as stakeholders like trade unions become aware of the new trend in the CCMA, they're naturally going to also equip themselves with the necessary infrastructure to be able to log on to online processes. The CCMA is also seeking cooperation and assistance from telecommunication service providers like Vodacom and MTN and so forth. As I said, the CCMA or the director of the CCMA envisages this to be the future of the CCMA. It is, of course, acknowledged that fairness and accessibility are key in rolling out the e-commissioner idea. And it's not anticipated that in-person hearings are going to be completely eliminated. There will always be place for in-person hearings. One of the major concerns, aside from the resources necessary to getting the system going, a significant concern is that there will be an increased number of postponements due to technological glitches. And there's also a fear that settlement rates will drop because, as I mentioned, generally rapport to facilitate a settlement needs to be developed in person, or that has been the thinking around the globe in family-related matters in the past. Overall, however, the CCMA believes that this initiative will benefit users and make the CCMA more accessible to citizens, and the CCMA is optimistic that the benefits will outweigh the difficulties. What I intend to do next is to examine the most common objections to proceeding with the process remotely and to give you an indication of how foreign courts have dealt with those same objections. The objections are raised around the globe in court processes really mirror the kind of objections that we see in the CCMA, where parties or one party doesn't want to proceed remotely. Developing nations, of course, have some unique problems to address. And in the first place, it's necessary to understand that a remote process, a hearing by way of video conferencing, is only going to be ordered where it's in the interest of justice to do so. And that will be, the interest of justice will be determined by taking into account naturally all relevant factors and will be case specific. So it's difficult to develop general rules. We're going to have to look at each situation, each scenario, each individual who's involved in the process and look at all relevant factors. But what I'm going to do now is to, sorry, my clicker is not working. What I'm going to do now is to highlight some of the considerations and maybe the obstacles that are specifically relevant in the African context as developing countries. And the first thing that we need to consider, sorry, I've gone too far. The first thing we need to consider is the digital divide. Not everyone has the digital literacy necessary to participate properly in an online hearing. And one of the key reasons for piloting the e-commissioner idea is to alleviate the necessity of commissioners traveling sometimes up to 8 hours to reach these far-flung rural areas. Now, that's all very well, but the users in these far-flung rural areas are likely to be the ones who are on the other side of the digital divide. They lack the necessary skills to participate properly on a remote basis. A second factor is the accessibility of the requisite technology, including the extremely high cost of data in Africa compared to the rest of the world. And we've heard that mentioned earlier. I can't remember who it was, but someone in one of our earlier presentations mentioned this concern. A second factor is, sorry, I've dealt with that. In addition to data, we've also, of course, got to have internet access and power. Hybrid processes can take place where a party who lacks the means to participate properly in a digital process might attend at the CCMA, while the commissioner and with the commissioner and the CCMA's technological infrastructure, and the commissioner and perhaps a witness might be hooked in visually. At the moment, the CCMA does not give part-time commissioners or the public their Wi-Fi passwords, but this is going to change in the near future. The CCMA has taken a decision in principle that Wi-Fi is going to be freely available to everyone at their premises. A third issue that's possibly especially relevant in the African context is the lack of infrastructure. As with the previous point relating to data, not everyone will have a suitable device with which to participate in a remote hearing. Ideally, one would need a computer with at least 2 or maybe even 3 screens. One screen being a document visualizer, one screen perhaps being a screen to contain notes and directions maybe from your client, and the other to show the pictures to represent the parties to the proceedings. Of course, it's possible to join a virtual hearing using only a smartphone, but I have some worries about that, especially when it comes to managing large numbers of documents. Doing that from a phone is going to be difficult. Tablets might be manageable. At present, the CCMA does provide the necessary infrastructure for parties who don't have the means to participate in a remote hearing. A fourth I've gone back too far. A fourth consideration is uninterrupted power supply, and this is perhaps especially relevant in South Africa at the moment because we're having a major power crisis, and the power crisis in South Africa is likely to persist for a significant time. As we all know, an adequate internet connectivity depends on an uninterrupted electricity supply. At the CCMA office that I work from in Pietermaritzburg, there are no generators or inverters, and I understand that this is the case at most of the CCMA offices. We South Africans are experiencing a state of disaster in relation to electricity, and load shedding happens daily, usually for about 2 hours at a time. Face-to-face hearings can proceed in the darkness and in the gloom. It's not great, we can do it. But of course, a virtual hearing would have to be stood down or adjourned if the power left. You might say, well, then the CCMA must schedule their cases around the load scheduling, the load shedding schedules, but the load shedding schedules are very unreliable. So this is not really an option. In the context of the e-commissioner pilot, the CCMA is considering making portable, uninterrupted power supply devices available to commissioners. And these devices apparently would enable power to continue for a 2 to 3 hour period, which would cover the load shedding period. Another consideration, and again, this is perhaps in South Africa especially, is that there are a lack of rules or guidelines regarding best practice with remote or virtual hearings. There are some best practice guidelines to borrow from, most significantly probably the remote hearing protocol of the Arbitration Foundation of Southern Africa, but otherwise good practice will develop out of the practice of holding these remote hearings. Next, I will consider relevant considerations in the labor context specifically. The first consideration is that with labor disputes, parties involved in such labor disputes are often in a long-term relationship with each other. And that is why labor disputes need to be resolved quickly and with a minimum of legal formality. Think about an unfair labor practice dispute where the employee is still employed by the employer, or a dismissal dispute where the primary remedy, if the employee wins, is for the employee to be reinstated. And yes, and as I've said before, it's easier to negotiate a settlement, especially where you have to rebuild relationships in a face-to-face process with the handshake factor, than on a remote platform where you can't even make eye contact between the parties. Something that I do need to mention, though, is the FAWU versus SAB case. FAWU is the Food and Beverage Workers Trade Union, and SAB stands for the South African Breweries. This is a 2020 decision. It was decided in the height of lockdown. But what happened was that SAB was embarking on a large-scale retrenchment, and they gave notice that the consultation process that they were required to hold in terms of the Act, they gave notice that that process was going to be conducted virtually. And FAWU approached the Labour Court for an interdict, if I remember correctly, declaring that this procedure was, or interdicting SABC from continuing with the process, saying that a virtual consultation was not procedurally fair. The Labour Court, but again, I do recognize that this was under lockdown conditions. The Labour Court had no problem with SAB conducting their consultations with the trade unions over a virtual platform. A second issue of particular importance in labor dispute resolution is the requirement that labor disputes must be resolved fairly and cheaply and expeditiously. And in South Africa, this is a statutory imperative. It's contained in Section 138 of the Labour Relations Act. And certainly if a great deal of traveling is required in order to conduct a face-to-face process, using an online platform will save costs and minimize inconvenience. However, it has been observed that online dispute resolution can be a slow process if technical glitches abound, and also because of factors such as that looking at a screen is extremely tiring. We've all experienced it on Zoom or Microsoft Teams. You need more frequent breaks when you're online than when you're not. It's also turn-taking becomes difficult because you don't have those non-verbal cues that signal to you when it's your time to talk. So parties often talk over each other and then everyone keeps quiet, and then, yeah, we've all experienced it. All these sort of things slow down the process. Another significant factor to consider is that in labor disputes in Africa, interpreters are often required. And interpreting over a remote platform is notoriously difficult. It's extremely difficult for the interpreters if they're not physically with the person that they're interpreting for. And for the witness as well, they need to develop trust in the interpreter, to trust that the interpreter is interpreting their words correctly and interpreting the questions correctly. And again, that trust is more easily built on a face-to-face basis. But who knows, maybe we're going to see e-interpreters as well. I'm now going to focus on some of the common objections to virtual proceedings that I've come across. I am running short of time, so I'm going to go faster than I had anticipated. But you can see that there are a large number of objections that parties raise. So the first objection that has been raised on occasion is that the evidence is so important that it can't be trusted to an online process. We need to deliver this evidence in person. So if you, so that has been raised as an objection. This evidence is too important. There are critical disputes of facts involved in the case. We need to explore and interrogate this face to face. But I would remind you of the Simmers versus Campbell Scientific Africa case, where the evidence was crucial. It literally was a he said, she said case of sexual harassment. And the court was happy with the witness having given evidence via an audio link, not even a video conferencing link. Another objection that's sometimes raised is that witnesses to encourage witnesses to give truthful evidence, they need to be steeped in the formal atmosphere of a courtroom or an arbitration hearing room. They also need to be under the supervisory physical presence of the presiding officer, and the cross-examiner needs to be able to confront them directly. So that's an objection that comes up quite a lot. And there's a lot of academic writing about the importance of the architecture of the court building or the arbitration hearing room. Of course, conciliation and arbitration hearing rooms are not nearly as formal as courtrooms, but the objection remains. This objection hasn't gained much traction with judges or arbitrators. A third objection is that document management will be problematic on an online platform. Initially, in the early days, judges were concerned about this and often used to refuse to allow proceedings to proceed on an online platform where there were going to be a large number of documents. And when I say large, I'm not talking about 50, I'm talking about 10 lever arch files. As time went by, though, courts became more comfortable with managing documents and getting the parties to manage their documents. And the attitude globally amongst courts in many countries has been that you have to maybe prepare a little bit harder. You have to ensure that your documents are at the other side, but there are facilities like Dropbox, Google Drive, OneDrive, etc., that have actually made the handling of online documents much easier than it used to be. Another objection, this is number 4, is that where there's a legal team involved and the legal team is separated, they are remote from each other. That's a handicap because the legal team can't communicate easily with each other. One of the Australian judges in the Federal Court of Appeal in Australia said receiving whilst in full flight a WhatsApp message with a document attached is not the same experience as having your gown tugged and a piece of paper thrust into your hand. And the judge then goes on to say that while it's not ideal, the legal teams may still communicate with each other. Legal representation is prohibited in some arbitrations, but certainly in the labor court and in the big serious arbitrations, we do often find either an attorney and an advocate or senior and junior counsel to whom this objection would be relevant. Another objection, this is number 5, is that the lawyers or the representatives of the parties will be deprived of the opportunity to read the bench or the arbitrator and to make submissions accordingly. This has been given short shrift by judges across the world. This argument hasn't, I don't think judges have liked the idea that they are read and that their submissions are adjusted according to the feel or the vibe that the judge is giving off. Another objection is that because remote proceedings are often more lengthy than face-to-face proceedings, contrary to common belief, the process will be drawn out. And related to that point is that if the proceedings are drawn out, they're going to be increased costs by virtue of the length of the proceeding, but also because of all the technology involved in the process. That's number 7, the increased costs. Another objection is that the process is going to be unmanageable because of all the technological glitches, and there are going to be a lot of postponements. Courts around the world have not been impressed with this one either. They've said even in real life, you have to be flexible. Sometimes a witness's flight might be delayed, and you would therefore swap around the order of witnesses. The court said so too. If one witness has a technological glitch, we'll move on to the next witness. We'll hear the witnesses out of order. So yeah, this hasn't really been an objection. None of these objections have really stopped the courts proceeding with remote hearings. The integrity of the evidence is an important one. This is the idea that you've got a witness sitting somewhere away from the court or the arbitration room. Who knows how they're being influenced? Are they looking at notes? Have they got secret legal representation that's actually prohibited? Are they being coached or prompted by a third party? This concern goes to the integrity of the evidence, and it is a real problem. In all of the documents of best practice and principles and guidelines relating to remote processes, it's suggested that there should be an official person with the witness so that that can be supervised. That's going to just compound expenses. So other ways of doing it would be to, on a fairly regular basis, asking the witness to pan the camera around the room. Or if the witness is in a dedicated venue, make sure that there's a camera located with a wide angle lens that can show the whole room. Cross-examiners hate conducting cross-examination over a remote process. They really like to get up close with their witness when they're cross-examining them. So parties who have to have important cross-examination to do often object on the basis that their cross-examination on a remote platform is not going to be effective as face-to-face cross-examination. But there's plenty of precedent, even in the criminal context, where you have fair trial rights at stake, where face-to-face cross-examination is not a guaranteed right. Related to cross-examination is the fact that the judicial officer or the arbitrator is not going to be able to read the demeanor of the witness, and demeanor of the witness is a clue to credibility. Judges around the world have said, actually, our experience have shown us that it's the opposite. We see the witness much more closely when her face is on a screen right in front of us than when the witness is sitting at the back of the courtroom or at the front of the courtroom, but away from the bench. And they've also said we can also pause, we can rewind, we can zoom in. Judges have said that actually reading demeanor is easier on a remote platform. What you don't get though on a remote platform is body language, visual cues. So if a witness suddenly starts fidgeting when a difficult cross-examination question comes up, the judge probably won't be able to see that, or the arbitrator probably won't be able to see that. And then the 12th issue is data privacy and security of the process. This is another significant concern. Third-party software programs like Zoom or Microsoft Teams are a security concern. They are prone to hacking. We've seen all of the clips, the hilarious clips on YouTube. And ideally, specially designed fit-for-purpose software should be used. And also blockchain technology should be leveraged to make the transmission of data safer and more secure. And Ms. Kate from Kenya and Olumide from Nigeria spoke to us about data security in the modern era. The last concern that I'll mention is whether the parties will be able to have side courses securely. Digital platforms do allow for side caucus facilities, but an uninitiated user might not have trust in the process. And trust in the process generally is also a concern. Virtual labor dispute resolution is still relatively new, and some parties, especially unsophisticated applicants, may not trust the remote process. And trust is crucial to the integrity and the success of the system. In conclusion, the combined judicial experience of foreign courts appears to be that they have been pleasantly surprised at how effectively remote proceedings can run. Despite trepidation in the early stages about technological glitches and the difficulty of cross-examining over a screen, experience seems to have shown that concerns were mainly overstated and that with flexibility and creativity, the problems can be overcome. Virtual labor dispute resolution has many benefits, including efficiency, cost effectiveness, and accessibility. However, potential obstacles exist or are perceived as existing. And overcoming the obstacles and creating trust in the online process is going to be key if virtual dispute resolution is going to become more mainstream. And this is the vision of the CCMA. The outcome of the e-commissioner experiment is eagerly awaited. I hope that I've managed to alert you to some of the considerations relevant to online dispute resolution, and I've tried to highlight the most common concerns and objections to an online or remote process. Personally, I believe that with dedicated training initiatives, as well as a vast injection of resources by the CCMA into the system, with that, I believe that the obstacles can be overcome, and I believe that virtual dispute resolution does have the potential to improve the service delivery of the various labor dispute resolution institutions. Thank you, everybody, for your patience and attendance.
Thank you very much, Nicci, for your insightful and I think very forward-looking presentation that you presented. Any questions from the floor? And do we have the roving mics out there? Here's the first question. Roving mics, please. Thank you. And if you don't mind, I suggest we answered each question directly after the question has been posed.
And good afternoon. I'm the Vice President of the Commission for Conciliation and Mediation in Mauritius. So we have the same way of working than the CCMA from South Africa. I still have my concern about online dispute resolution, because when you have cases before you, the demeanor of the union or the disputants or the management, it differs. So this is something that you can't have when you're having a dispute resolution online. So I don't know how many cases, I've seen the number of cases that were resolved and everything, but I don't know if they were resolved or is it the number of cases that you've heard only?
Okay, thank you for that. Yes, there are concerns. And I did mention at the beginning that one of the concerns about this e-commissioner pilot, not problem, I'm foreshadowing the answer. The e-commissioner pilot is that there are going to be fewer settlements and objections to the process. There's going to be intense empirical research conducted once the e-commissioner pilot has started, which is going to be soon. But that will be studied and we will see whether online dispute resolution works. There's a desperate need for empirical research about the impact of trying to resolve disputes online versus in person. And that will be conducted.
Yes, because having conciliation and mediation is completely different from being in court. I mean, there's more involvement of discussion and everything when you're having a conciliation and mediation as opposed to be having cross-examination or evidence in court. So it does make a difference, even arbitration also.
The reason that I'm not throwing my hat into that ring right now is because, to my surprise, the pre-conciliation process is really effective, and that doesn't involve face-to-face interaction. I've heard that up to 70% of disputes are settled at the pre-conciliation stage. I don't know if that figure is absolutely correct, but I've heard that it's a significant percentage of cases that are resolved just by a phone call. So if that's the case, then maybe we'll be pleasantly surprised by the settlement rates. But the CCMA certainly shares your concerns.
Thank you. I think there was a question. Did you have a follow-up? No. I think the gentleman at the back has got a question. How can we get a mic to the gentleman at the back?
Hi, still Benoît Lopez and still from the University of Paris Saclay. So thank you for your presentation. And my question is, you talk about in situation face-to-face, and that remind me in France, we have obviously this kind of issues because of the pandemic. You accept to proceed of hearings in videoconference, and in criminal matters, the response was different. In labor matters, it's okay, it's not that less important, but we accept that. But in criminal matters, that we have a problem about that. And for example, in France, when you have a death on the construction operation, it's criminal matter. It's not labor law, labor tribunal issue. So my question is, do you think you can have this kind of distinction when you are in a workforce problem, but relevant for criminal law?
Thank you.
So with the criminal context, there are different considerations at stake. We have the constitutional fair trial or fair trial rights are imperative. Thank you. Oh, sorry about that. So it is different in the criminal context. However, even in the criminal context in South Africa, at least, I'm not sure what it's like in France, we do, the criminal system does use video conferencing, but mostly for bail applications, mostly for adjournments. Also where there's a child who's giving evidence, the child will give evidence via an intermediary in a room that's only connected by video conferencing technology with the court. And our courts have found that that's constitutional and consistent with fair trial rights. So I don't think full criminal trials will ever be run entirely remotely. But there is, in South Africa, there's a fair amount of use of video conferencing software and facilities, even in the criminal context. Thank you.
Thank you. I think then time for a final question, if any. On that note then, thank you very much, Nicci. Excellent presentation, was very insightful, and I think the CCMA is doing wonderful work, but also doing it scientifically. On that note, I'm going to hand a present over to you, and to the rest of the colleagues and delegates, thank you for your attendance today. I think we had wonderful papers and looking forward to seeing some of you at the cocktail function afterwards. Hand of applause.